Good morning. Sorry for being a bit tardy this morning. There was a little bit of traffic and then y'all definitely wanted me to have coffee. So thank you for your patience. I appreciate it. I'm going to go ahead and just get started and run through the calendar real quickly so I can get you guys on your way. Katara Flakes versus Marta. My understanding, I think I've realized now in looking at the calendar that counsel for Ms. Flakes has leave today.
Yes, Your Honor.
Thank you. And Ms. Shockley, you're here on behalf of Marta, is that right?
Yes, Your Honor.
Okay. So really the only reason y'all were on the calendar today was so that we could discuss a time for a bench trial in terms of scheduling. And so probably what I will do is maybe have my staff attorney reach out and see if we can schedule a brief Zoom call sometime next week, just for maybe 15 or 20 minutes so we can figure out, are there any issues we need to resolve and when is the scheduling going to work for the plaintiff and Marta for a bench trial. Okay.
Okay. I
Okay.
know the plaintiff is out of state, so I know that was something that he wanted to address. So
Okay.
I'll let him know to anticipate next week us getting together.
Yes, fair enough. And like I said, it'll be very informal. I mean, it'll just be a quick Zoom call that we can jump on so that we can discuss those issues and we'll go from there. Okay.
Okay. Thank you, Your
Thank
Honor.
you, Ms. Shockley. You're free to be excused.
Thank you. Have a good weekend.
You too. Okay. American Express National Bank versus Regina Howard.
Good morning, Your Honor. Tara Gardner here on behalf of American Express.
Hi, Ms. Gardner. Um, have you had any contact with Ms. Howard or expected Ms. Howard to appear today?
I have not. We did send in our portion of the pretrial order, and as Ms. Howard isn't present today, we would request that the answer be stricken and take default.
Okay. So what I'm going to do, Ms. Gardner, feel free to, hang out and multitask and do other things if you need. I'm going to give Ms. Howard some time to see if perhaps she did. I was late, so I'm going to give her a little grace to see if she was late. And then at the conclusion of the hearing, Ms. Gardner, if she has not appeared, then I will entertain your request. Okay, Ms. Gardner?
Thank you.
Thank you. Disma King Marie King versus Greenbrier Marketplace and Albert Ashkuti.
Hi, good morning, Your Honor. You may see James, also have Corey Wagner on. We're here on behalf of the defendants Greenbrier Marketplace and Albert Eshkuti.
Okay, thank you, Ms. James. And forgive me, tell me who else you said you had here on behalf of the defendants.
Corey Wagner.
Corey Wagner.
Corey Wagner. Hi, Ms. Wagner. And who do I have on behalf of the plaintiffs? Ms. James, did you have you been in contact with the plaintiffs' counsel or the plaintiffs in this case?
Not recently, Your Honor, not since we had copied plaintiff's counsel on our email correspondence to the staff attorney about our motions being pending.
Right.
He was on the same email that said that it was an entrance order. So nothing further beyond that, scheduling this morning for our hearing on our pending motions.
Okay. Mr. Freehoff, if you can please check in our system and see if anyone opened that notice. And so who we might reach out to find out if we can expect anyone's appearance today.
Yes, I will check both the emails mentioned by Ms. James and eFile Georgia to see if anyone opened the notice.
Okay. Ms. James and Ms. Wagner, if you guys will just sit tight for a bit, okay? Thank you. James Griffin versus Freedom Mortgage Company.
Yes, Your Honor. Good morning.
Hi, Mr. Griffin.
Yes, ma'am.
And who do I have here on behalf of Freedom Mortgage?
Good morning, Your Honor. Eric Badia here on behalf of Defendant Freedom Mortgage.
Hi, Mr. Badia. And so I just want to make sure procedurally we're all in the same place. So obviously y'all were originally noticed for this hearing on a motion to stay discovery while the court rules on a motion for judgment on the pleadings. This was after the case had been removed and then was subsequently returned to the court. I did note that Mr. Griffin had filed some amended complaints. And so as a result of that, Freedom Mortgage filed, I think, renewed motions for judgment on the pleadings, and I think I just saw, Mr. Griffin, a response come through. Is that correct?
Yes, ma'am.
Okay, excellent. How long do you think it will take for that presentation, Mr. Griffin? Or actually, I'm sorry, Mr. Badia, it's your motion. How long do you think that will take, sir?
Your Honor, I don't expect more than 10 to 15 minutes. Certainly, if Your Honor has questions and it goes beyond that, I'm happy to answer anything, but my affirmative presentation would be very short, Your Honor.
Okay, Mr. Griffith, Mr. Griffin, what do you think about the timing in terms of any response that you would like to make? How long do you think that might take, sir?
It should be relatively short, Your Honor.
Okay. Okay, so I'm gonna say about 20-ish minutes, and I'm gonna move on for other announcements, and I'll call you guys when I'm ready, okay?
Yes, ma'am.
Thank you.
Thank you, Your Honor.
Lawrence Davis versus all that tract, 719 Karen Circle Northwest.
Good morning, Your Honor. This is Reggie Snyder here on behalf of the City of Atlanta.
Thank you, Mr. Snyder.
And Your Honor, this is Shannon Sams on behalf of the Investor Services.
Okay, and do we have anyone here on behalf of Lawrence Davis?
I'm sorry, Your Honor, Lawrence Davis, I'm saying City of Atlanta. Effectively, that's the same thing.
Okay, just making sure.
Yes, ma'am.
That's okay. I appreciate that. Sorry, Mr. Snyder.
No, you're fine.
Okay, and what is the status of this matter, Mr. Snyder?
Your Honor, we've completed service on all the interested parties. We recorded a notice of lis pendens. We published the notice of the filing of the in-rem petition, everything statutorily that we were required to do. The only party that's filed an answer in the case is Mr. Sam's client, Investa, and we have sort of a standing understanding that as long as we don't contest their tax 5A liability, then they don't have an opposition to our in-rem petition. So we have no problem with them. And as far as I know, no other parties have filed an answer. So we are at a point in the case where I think we would ask for an order allowing us to proceed with the in-rem foreclosure sale.
Okay.
Once the sale is completed, Your Honor, we would notify the court to let you know if anyone bid on the property and bought it. If no one did, then the city would seek an order from the court, basically giving title of the property to the city. Either way, we would come back to you and we would notify you.
Okay. And Mr. Sams, I assume that subject to whatever interest is still protected or asserted, it sounds like by agreement for Investa, that you would have no objection to that. Is that correct?
Well, actually, I'm just here out of an abundance of caution. Initially, we had an interest in this case,
Yes, sir.
and then all the liens got paid off.
Okay.
So,
Okay.
yeah.
Well, that makes it even easier, Mr. Snyder.
There you go.
If you could do me a favor and please, if you have not done so already, submit a proposed order that authorizes the relief you request. I do like Mr. Sams knows. I like an order that when it involves real property like this, it is helpful to me if you could put a little more detail in the order in terms of these are all the people, these are the efforts we made to serve them. No, everybody is hopelessly in default because no one responded. The claims that were protected by Mr. Sam's client have subsequently been satisfied, et cetera. And then the relief that you seek. And that way we all have one order that we can go look at and we'll know what the status of the case was at that time. Okay.
Absolutely, Your Honor, I understand.
Thank you so much, Mr. Snyder. I appreciate that.
Just one thing to add, Your Honor.
Yes, sir, Mr. Sams.
I filed an amended answer on 1019. So there should be something in the record that shows that the liens got paid as well.
Excellent. Okay. And the dockets are numbered now under the events tab. So if you can see the documents, you can say it's docket number 17. That was one of my most important things I've done while I've been at this court is get the docket numbered so that you can just say docket number 1, docket number 12.
Vis-a-vis the federal court.
Exactly, because I used to practice in federal court and it's a lot easier to cite prior document filings. So in any event, I reference that only so that whatever amended answer Mr. Sams is referencing, that you'd be able to reference it pretty easily in your order. Okay, and then again, Mr. Snyder, this is a different parcel of land at 1111 Oak Knoll Terrace?
Yes, Your Honor. That case is a little bit different. It's the same type of in rem petition. We served all the parties, which was only 2 parties. Mr. Sam's client is not actually involved in that. Most of the time they are. But in this particular instance, it's just 2 folks, Ms. Christopher Coleman, and a woman, I think of her name is Chandra Frazier.
Frazier, yeah.
We served both parties. Mr. Coleman filed an answer. Ms. Frazier did not.
Okay,
I believe Mr. Coleman is on the call to this morning, Zoom meeting to this morning. But Your Honor, his defense is essentially that he claims the city did not provide him notice of the in rem hearing, the administrative in rem hearing, when the actual demolition hearing was held, and the order allowing the demolition to move forward. We obviously dispute that. We have a list, I guess the attendance list for the hearing where he was listed as one of the attendees at the demolition hearing. I obviously was not
okay,
counsel at the time,
right.
but he's here and he can talk about the fact that he was at the hearing when the city was considering the demolition of the property. We have photos of the property, the condition of it. It had gone through a fire, so it was in really bad shape.
Well, Mr. Snyder, forgive me for interrupting, but
Sure.
it sounds like we've got a little more to sort through on that case. About
Yes,
how
Your Honor.
long do you think it might take for you to just generally make the presentation for the relief that you're requesting?
Probably 15, 20 minutes, Your Honor.
Okay. Mr. Coleman, are you on the call? Can you unmute and turn on your video, please? Hi, Mr. Coleman.
Hello.
So I think you probably heard Mr. Snyder giving me a brief rundown. I sort of interrupted him because it sounds like we need to have a little bit of a substantive conversation about what's going on, particularly related to what Mr. Snyder indicated was a defense that you have raised about not being given proper notice from the city regarding the prior in rem proceedings. And so my question to you, Mr. Snyder indicated he thought it might take about 20 minutes for us to sort of talk through those issues. Does that sound about right to you, Mr. Coleman?
Sounds about right. The only question I have is, no one's made notice that I've actually paid nearly $26,000 for the house to be torn down.
Okay.
So,
Well,
I'm not sure.
I forgive me, Mr. Coleman, but I will hear all that from you in just a few minutes. And I'm just trying to get people that don't still need to be here on their way, and then hear from the people who do still need to be here, which would include you and Mr. Snyder. Okay, Mr. Coleman?
Okay.
Thank you. So if you could sit tight for just a minute, I'll get right back to you. And then I have Eric Stroud and Sean Stroud. Nope, that one is at 1 o'clock. Is that right, Mr. Freehoff? Yep. Okay. So let me go back then. So I think what I have. Okay, I'm going to go back to Mr. Griffin versus Freedom Mortgage Corporation. Now I see that at least I thought, yeah, I see that we have a court reporter on the call. Is that that's not regarding this matter. Okay, that's regarding the matter where we're still waiting on counsel for the Kings to appear. Okay, so if you guys can sit tight with just a few more minutes, I'm going to go ahead and take up this matter.
Judge,
Yes.
I apologize to interrupt, but since you just mentioned it, I can confirm that Mr. John Bay, the attorney for the plaintiffs in the Disma King matter, did open the notice on March 27th. So he should have notice of this hearing. Would you like me to call his office?
Yes, please.
Okay.
Thank you. Okay, while we wait, I am going to go ahead and take up James Griffin versus Freedom Mortgage Corporation. Mr. Griffin and Mr. Badia. So this is going to be a hearing on the defendant's motion for judgment on the pleadings. Technically, there's a motion to stay pending as well. The motion for stay, I assume, is associated with to stave off discovery until the court decides if there is, if the case survives initial motion for judgment on the pleadings. And Mr. Badia, since it is your motion, I will let you go ahead and proceed. Now, I will tell you, I have read the motions. I like to tell you what I think I know about the case so that then you can decide what part I've gotten wrong or what part you should focus on. But what I think I understand is that there was a home that was owned, I believe, by Mr. Griffin's father before he died, and that Freedom Mortgage held the mortgage on that property. And that Mr. Griffin's case is associated with efforts by Freedom Mortgage to recover on its interest. But there's a dispute about whether Freedom Mortgage has taken any action relative to the property that would be actionable by Mr. Griffin as either an heir or an administrator of an estate, which is a little bit less clear to me. And someone who I think, at least in the most recent pleadings I have seen, has not assumed the mortgage formally. So that's those are the facts I think I understand. And if you want to sort of take it from there, Mr. Beatty, and then I'll hear from Mr. Griffin.
Good morning, Your Honor. Yes, that is, I think everything you said is accurate, and I appreciate the court doing that. I also appreciate the court's docket's efforts. I really think that's super helpful, that you mentioned before. But back to business here. So yes, I think Your Honor is correct. A couple other just factual points that I think are relevant here to set for the court. So you're correct that plaintiff's late father closed on the mortgage at issue in August of 2020, August 10th of 2020. That mortgage was used to purchase the property that's at issue in this case, and that's at 189 Durham Lakes Parkway. The original amount of the loan was $356,662. Mr. Griffin's father unfortunately passed away very shortly thereafter, in October of 2020. Your Honor, you mentioned about the standing issue, and I think I just want to clarify on that point quickly before I go into the rest of the presentation. Initially, when Mr. Griffin filed the complaint was originally filed in March, but was not served until June of last year. Case was removed at that point based on diversity and some federal questions that were in the complaint. At that point in time, that original complaint did not allege that Mr. Griffin was the administrator. And so the Northern District of Georgia considered the arguments. We made a motion to dismiss, considered the arguments, found that he did not plead that he was the administrator. There was no standing to bring the claims, and therefore remanded back to state court. Mr. Griffin has now pled that he is the administrator. He has attached the court order from the probate court showing that. So Freedom is not questioning that at this point. I just wanted to make that clear.
Thank you for that clarification. I appreciate it.
Yeah, we're not asserting that Mr. Griffin is not the proper heir. We assume, based on his representations and the probate court order that he filed, that is true. The issue is, Your Honor, Mr. Griffin has brought, I believe, 6 different counts. All of them can be decided as a matter of law by the court, because just legally, without getting into any factual disputes, the claim's not viable. And so I'm just going to run through those very quickly. And I would like to just also point out to Your Honor, without getting into anything substantive, but I anticipate that Mr. Griffin might discuss communications and settlement talks that were happening between Freedom and him and his other family members. So I don't want to get anything that would be barred by Rule 408, but I will tell the court that there have been ongoing discussions. And so, this has been going on for several years now. Mr. Griffin unfortunately passed away in 2020. Freedom didn't even initiate foreclosure until March of 2023. And so I just want to point that out for the court here. The timeline, I think, is important to keep in mind. This has been going on for a long time. And so going to the legal points, Your Honor, quickly, on wrongful foreclosure, injunctive relief, there is no pending foreclosure at this point. Georgia law is very clear. We pointed this out in our brief and cited cases. If there's no foreclosure sale, which there is not here, then there's no wrongful foreclosure action. Mr. Griffin has not tendered the amounts due, and so therefore there's no possible injunction to stop a foreclosure, even if there was a foreclosure pending. And we cited the Oconee case and the Crawford case on those points in our briefing. Regarding Mr. Griffin has made a few federal consumer protection law claims, TILA, Fair Debt Collection Practices Act, and Georgia Fair Business Practice Act. I'll touch on those quickly. Your Honor, on TILA, it's to be frank, it's not crystal clear which part of TILA Mr. Griffin is claiming under, but in any event, there's no viable TILA claim here. If Mr. Griffin's claim is that there were disclosures that were supposed to be made to his father in 2020, those are clearly time barred. The court is, under the Moneta case that we cited, the court is allowed to review documents attached to the answer that indisputably includes the mortgage contracts at issue in this case, given that the claims arise out of it. That document shows Mr. Griffin's late father purchased the house through this mortgage in August of 2020. Under TILA, any notice claim would have to have been brought in 2021. And this case was not filed till March of 2023. It's not clear again that Mr. Griffin is trying to make a TILA rescission claim, but to the extent he is, this is a residential mortgage transaction, which the 11th Circuit has found is not covered by TILA rescission. We cited the Cooper case, which I think is pretty much directly on point. In that case, the 11th Circuit was in a similar procedural posture. It looked at the mortgage documents. It saw that that was the purchase of a home via a mortgage, an initial purchase, not a refinance, HELOC, and found that TILA rescission does not cover that type of transaction. So again, as a legal matter, no rescission claim. On the FDCPA, we have cited several 11th Circuit cases. These cases, as Your Honor is probably aware, tend to happen more in federal court than in state court, so there's not as much state court law here. But the Northern District of Georgia, the 11th Circuit has routinely and uniformly found mortgage loan lenders and servicers, which Freedom is, are not covered by the FDCPA when they're trying to collect on their own debts. And that we cited the Tate case, Warren, Graham, McWeevy, and so I won't go into depth on those because they're in our brief. But again, as a matter of law, if a mortgage loan lender or servicer is just attempting to collect its own debt, there is no FDCPA claim because they are not a quote unquote debt collector as that term is interpreted under the Fair Debt Collection Practices Act. On the Georgia Fair Business Practices Act, I would like to bring the court's attention to one case I found while preparing for the hearing. My apologies for not including it in the briefing, but there's a Georgia Court of Appeals case from last year that squarely agrees with all the case law that we cited, showing that Georgia Fair Business Practices Act does not apply in the case of residential mortgage transactions. And I'll cite that for the court, and I'll give you the site. It's Marques, Marquess v. JP Morgan Chase. Citation is 370 Georgia App 305, pin site 311, and it's from 2023. And in that case, I'll just read the quote. The trial court dismissed Marques' claims for violation of the Fair Business Practices Act, OCGA 10-1-390, on the ground that the act does not apply to residential mortgage transactions, period. We agree, period. And it dismissed the case, or it dismissed the claim, excuse me. So I think that one is also very straightforward. Again, not a factual dispute. It's simply, this is a residential mortgage transaction. There's no GFBPA claim. And Your Honor, I would next like to just move quickly to the Fair Housing Act claim. That is a new claim that was added in the most recent amended complaint. This is now the second amended complaint. Your Honor, there's a couple issues with this. I won't belabor it because Your Honor has said that she's already read the briefing, but there's two key issues here. One is all of the claims, all of the allegations are may have or something to that effect. They're not even claims that Freedom has actually done what is said. Paragraph 1, paragraph 10, 27, and 28 in the complaint. Paragraph 1, plaintiff raises concerns of potential racial discrimination. Paragraph 10, Freedom Mortgage may have participated. It may be determined that defendant engaged in. 27, may constitute discrimination. So, Your Honor, quite frankly, that just doesn't, even under Georgia's lenient pleading standards, that doesn't fly, because if there's no evidence, if plaintiff doesn't have a good faith basis to bring the claim, it doesn't merit the claim moving forward. The second issue is, even on top of the fact that these are pleaded as a may have or hypothetical, there's no foreclosure sale here. And plaintiffs' allegations are essentially that Freedom allegedly foreclosed on minority-owned homes in a certain area, and discarded with or got the equity from those homes by foreclosing on them wrongfully. Well, no foreclosure has happened. So this is completely hypothetical. And the last point I'll make is, even under plaintiff's theory, the theory just doesn't legally make sense, because as the court is surely aware, when a lender forecloses, if there is a surplus, if there's equity in the home, any surplus at a judicial foreclosure sale would go back to the borrower or to any other junior lien holders. Essentially, Freedom does not get that money. And so the theory that Freedom is wrongfully foreclosing on these homes to steal the equity is just doesn't make sense legally. In addition to the fact that there's no pleading or evidence that it happened. Your Honor, a couple of just last points I'd like to make, and then I'll answer any questions you have and let Mr. Griffin make his presentation. I reviewed Mr. Griffin's response. There are two cases cited in there. And I'm sorry, let me just briefly touch on the breach of contract, because I did not touch on that. Your Honor, Mr. Griffin's claim as to breach of contract appears to be two bases, and he can correct me if I'm wrong, but I think a fair reading of the complaint is Freedom failed to give notice, and Freedom failed to essentially work with him in good faith to assume the mortgage. So, Your Honor, as to the second point there, kind of working with him, there's no duty under this contract to work with the borrower. The contract allows Freedom to accelerate the debt, to charge fees. Mr. Griffin hasn't raised any specific contractual provision that Freedom is alleged to have breached. And as the court knows, there must be some provision, some contractual duty that Freedom has breached. We've attached.
Let me just to make sure so the underlying mortgage contract would have been between Mr. Griffin's father and Freedom. And so while certainly if a contract was breached, the estate would potentially have a cause of action against Freedom, it would have had to have been a breach relative to the deceased Mr. Griffin, correct?
Correct, Your Honor. That's exactly right, because as you pointed out correctly in the beginning, no one has assumed the mortgage at this point. The mortgage is still in the name of Mr. Griffin, the plaintiff's father. And yes, and that is correct. So that's one issue. And then the other issue as to notice, Your Honor, I think just at a high level here, on the foreclosure point, if it's the notice of foreclosure sale, well, the foreclosure sale is not moving forward. It's not pending. It hasn't happened. So if Freedom down the line was to initiate another foreclosure, well, it's going to issue a new set of notices. So that's, again, a hypothetical. There's no issue as to the notices that have gone out, because that sale is not going forward. And so that's hypothetical. And then if there's some issue as to notice on the underlying contract, well, again, the sale hasn't moved forward. So if the point of notice is to cure, respectfully, again, the estate has had plenty of time to cure here, and certainly has notice. And I point out in the brief that the Exhibit 3 to Mr. Griffin's second amended complaint is a letter asking about the alleged default, or as he alleges that it's an alleged default, but the default under the mortgage. So clearly he had notice. And so, Your Honor, I think the point here at a high level is, again, we're talking about things that may happen in the future that simply are not relevant. And again, I would point out that the sale is not moving forward. And so, if this is a claim as to some future foreclosure action.
Okay. Thank you, Mr. Beatty. I appreciate that. Mr. Griffin,
Yes,
now would be, I'm sorry, I thought you were done. I apologize, Mr. Beatty.
Just 2 seconds. I just want to point out 2 quick things. One is, Your Honor, Mr. Griffin attached some exhibits he filed a notice of filing yesterday for exhibits to be considered. I would ask the court not to consider them, not because there's anything that we're concerned about, just to kind of preempt an argument from Mr. Griffin. The issue is, as Your Honor knows, it cannot consider extrinsic evidence, the mortgage contract being an exception as indicated in the Moneta case that we cited. Exhibits attached to the complaint, for example, contracts that underlie the dispute, the court absolutely can consider in a 12b6 or a judgment on the pleadings, but extrinsic evidence such as the complaint and other websites that Mr. Griffin has attached to in his notice of filing should not be considered by the court. I will say at a high level again, without the court having to consider those, that there's nothing in there that would support any type of claim that Mr. Griffin has asserted. I take it that he's going to argue that those are related to the Fair Housing Act claim, but there's nothing in there that shows any kind of discrimination. And so I would just like to reserve a little bit of rebuttal time if Mr. Griffin argues that point, and I'll leave it at that.
Okay, well, generally speaking, Mr. Badia, whoever's motion it is always gets the last word in terms of a brief rebuttal. So that will not be an issue for you to be concerned about. But I appreciate you identifying the issues from your client's perspective. And Mr. Griffin, I'm now going to call on you to respond, sir.
Yes, ma'am. Well, first of all, ma'am, Eric, defendant stating that the foreclosure started in March of 2023 is an absolute falsity. The mortgage foreclosure started, I believe, in 2021, 2022, but we cannot ascertain the exact date of when the foreclosure started, just based on the fact that my family, the heirs, and me as administrator have been blocked from the account, blocked from receiving any type of information, blocked from any access to any documents other than the ones defendant has presented in this particular case. Therefore, not only did we not have access to be able to cure, we didn't have access to even review documents. We never received notice. And for defendant to say that it started in March of 2023 is absolutely absurd. Secondly, defendant submitted a note in an email in federal court that answered to the judge, Sarah E. Gerety, I believe, and her law assistant, that stated that Freedom Mortgage had only put the foreclosure on hold based on the fact that another heir filed a bankruptcy. So Freedom Mortgage stated that they were in foreclosure against the property and that the property was supposed to be sold on March 4th on the steps of the court in Atlanta.
Mr. Griffin, let me ask you, let me interrupt you for just a moment. So I think that what I understand Mr. Badia to be saying, and what I believe to be correct about the foreclosure process, is that the foreclosure process in Georgia is very, it's very specific about the items that a foreclosing entity must undertake and the process in which they must undertake those actions.
Yes,
and
ma'am.
so I think I understand Freedom Mortgage's position just relative to the wrongful foreclosure to be that although they might have previously initiated a foreclosure proceeding or started the process, they've not actually filed a foreclosure. They've not actually taken that next step to officially foreclose on the property. Even if they did previously, they've withdrawn it. And so their point is, while they might still try to foreclose in the future, because there is not an active current foreclosure happening, there can't be a claim for wrongful foreclosure right now. Now, if they were to later try to foreclose, you could potentially assert the same issue and argue this is a wrongful foreclosure. But their argument just on that issue is that there is no active foreclosure. There may be, the process in the background may be occurring, and at some point that may happen, but currently there is not one. So I don't think that he's saying that they don't intend to foreclose or that they never tried to foreclose. I understand him to be saying that that legal process is not currently occurring, and therefore there's no wrongful foreclosure that can be responded to it currently. And I say that only to focus what you're responding to, because I understand what you're saying, and I believe that it's probably factually accurate in terms of what was going on previously and what you understood to be happening. But their argument is they're not taking those actions currently, and so there's no argument that any foreclosure is wrongful because they haven't actually attempted to legally foreclose on the property currently. So that I just wanted to add that for you, Mr. Griffin.
Yes, ma'am. So for a common definition of foreclosure, that means that there actually has to be a sale and nothing that happens prior to that is considered foreclosure?
No, sir. It's that there has to be, the legal process has to have started with all the notices that are attendant to it prior to that foreclosure sale taking place. And what I understand, I think, is that Freedom Mortgage may have originally undertaken some of that process, but then abandoned that process. And because they've now abandoned it, that would mean that if they want to foreclose, they would have to start over again from scratch with the appropriate notices and things that take place before you ever get to a foreclosure sale. And because that has not occurred, there is not a foreclosure that is intended or in process currently.
Well, that is an issue of debate that needs to be further reviewed in discovery, because based on my interactions and based on the fact that I spoke with somebody at Freedom Mortgage Bank on March 27th, and they, let me see, it was a young lady by the name of Shania, and she's in the department that takes care of the foreclosures, and her ID number is 3731. She stated that not only are they in process of the foreclosure, but the hold for the foreclosure is going to be removed on May 31st. And I believe those phone calls are actually recorded. And then they have never stopped in the process of foreclosure. So Freedom is not being as candid or forthwith as they should be. Also, in reference to wrongful foreclosure, the defendant's initiation of foreclosure proceedings without proper notice, refusal to accept mortgage payments from an estate constitute wrongful foreclosure under Georgia law OCGA 44-14-162.1. Heritage Creek Development Corp. versus Colonial Bank 601 SE 2nd 2D 842. GACT App and 2004. As a direct and proximate result of defendants' wrongful foreclosure proceedings, the estate has suffered damages, including but not limited to the loss of property value, equity, economics, harm, loss of income, legal fees, lost wages, and numerous other losses. Also, in reference to hold on a second. Defendant's failure to provide notice does not mean that the foreclosure process, wrongful foreclosure, is not a proper count. Them not providing notice in any part of the process is illegal, just based on the law. Like, they have to provide notice. It's also, they have to also provide based on the CARES Act and other federal acts, because my father died shortly after Freedom's alleges that he signed this contract. And based on Freedom's previous mortgage abuses and everything, I personally don't feel that anything they say can be trusted, and everything that they do needs to be examined, because they have been found guilty on numerous occasions for mortgages abuses. They have been fined for millions of dollars for that. They have been fined for falsely filing irregularities and putting in wrong information. They have also been sued and found guilty for falsifying documents. So taking them on their word, I believe, is a mistake, and that the court needs to go through discovery to actually parse through everything that Freedom is saying to ensure that justice is properly served. In reference to one second. In reference to my standing, I became the temporary administrator back in March, prior to the sale that was supposed to take place on March 4th. So the sale was supposed to take place on March 4th. My sister, who's an heir, she filed bankruptcy, and the bankruptcy stopped the foreclosure, the actual sale, on March 3rd. So Freedom stating that no foreclosure took place and they never got to the process and they stopped it, all of that is untrue, especially since they submitted an email to the federal court stating that they only put it on hold based on the foreclosure. And as soon as that is resolved, they will resume. Also, based on the fact that Freedom Mortgage employee 3731 explained that it's on the books that it's on hold until May 31st. That doesn't sound like they stopped. It just sounds like they stopped for 1 second, just to allow themselves to say that they have stopped the process. But this process hasn't stopped at all. On March 8th, they sent someone to the property in question that we are discussing presently, and that person illegally was trespassing and taking pictures and looking in the windows and terrified my sister and her grandchildren. And then from the window, she says to him, "Why are you here?" He says, "I'm here in representation of Freedom Mortgage for the property." So Freedom Mortgage stating that they're not in foreclosure and they haven't gone through the process, and
Mr. Griffin, couple things, okay?
Ma'am.
One, I absolutely understand why you would be frustrated with this process and unhappy with Freedom Mortgage. But there are a couple things I want to point out. Number one, you don't have to convince me that you have standing because Mr. Badia has already conceded that when they originally argued that you didn't have standing, it's because you had not formally been named the executor or the administrator of the estate, but you have been now named the administrator of the estate. So there's no dispute, as far as I'm concerned, that you are the appropriate person to bring claims on behalf of that piece of property that was previously owned by your father. So that's number one. Number two, I know it can be frustrating, but procedurally, the point where we are right now is about the legality of the claims that you have asserted, whether they are lawful claims that can be asserted if you were to be able to prove everything that you have alleged, right? If there would be relief here. And the argument by Freedom Mortgage, for the most part, is that even if the court accepts everything that you have alleged in your complaint as being true, there still isn't a legal cause of action for that. And so I want to focus for you that for purposes of today, you don't have to convince me about all these facts and the wrongful actions that you allege were taken by Freedom Mortgage, because for purposes of my analysis of this claim, I'm going to assume all those things are true for right now. Now, if the case goes forward, then obviously I would need to hear evidence and a finder of fact would make those decisions. But procedurally, where we are now is I'm going to assume that everything you've said in your complaint is true for purposes of this motion, and then decide whether a cause of action exists if those facts are true.
Okay, yes, ma'am.
Okay.
Thank you. Appreciate you. In my count number 2 in breach of contract, Freedom has blocked my family and myself, even after I became administrator. They have blocked me from all access to the account. They have blocked me from all documents, other than the one document of the contract that Freedom provided on, I believe, February 15th, which was the, I believe it's the note. I'm not exactly sure right now. I don't have that document in front of me, but that is the only information, the only access that we've been given to the account. In order for the contract to be considered legal, I have to be given access to it. I have to be given access to the ability to cure the loan. I have to be given access. Myself, even after becoming administrator, we have been blocked from all access to any documents to the mortgage account. Freedom claimed that we are in negotiations We are not presently in negotiations. So therefore, not only was I blocked out of the account, and like Freedom made an offer, right? But that's not a negotiation. They made an offer that was totally unacceptable. And I have not responded with a counter offer. You know, hopefully we'll get to it. But at this present, you know, in order for the contract, as the administrator, I have the right, and legally, I have the right to have access to the account so that I can move forward on any legalities concerning the administration of my father's estate. Now, I became the administrator, the official administrator in September, and it is now April, and I have been blocked from any access, from any documents, anything. That being said, I find that they are in breach of contract, and that I should be allowed to go forward with discovery, because in order for me to administer the estate, I have to have access to the documents that control the mortgage, that control the estate.
So, Mr. Griffin, let me ask you a question on the issue of the breach of contract. So you might have heard me ask this question to Mr. Badia, but generally speaking, when the court looks at a breach of contract claim, right, there's no dispute here that there was a contract between Freedom Mortgage and your father for the provision of a mortgage so that he could purchase the property that is the home that is at issue. But generally, when the court is looking at a breach of contract claim, what I start by doing is looking at what are the obligations that the alleged part, like what obligations did the parties have under the contract? And so when you say Freedom Mortgage breached the contract, what I'm supposed to be doing is looking at what were Freedom Mortgage's obligations to your father under the contract. And what I'm hearing you talk about, which no doubt very frustrating, is an inability to access the system and an allegation that you didn't receive notices about the foreclosure. But I don't know the extent to which Freedom Mortgage is obligated under the contract to do any of those things relative to your father. And so that's what I'm trying to figure out is what is it that you believe Freedom Mortgage did wrong relative to your dad when there was the contract between the two of them?
Okay, so since my father died shortly after, and Freedom filed foreclosure and began foreclosure process after his death, right? So that means that we have to, this is just my perspective, and you can explain if I'm wrong, that Freedom actually has to deal with notice and everything to the estate, because
Okay,
my father died 2 months after. So therefore, it's not about the violation to my father, it's about the violations to the estate of my father.
Okay, I understand.
All right. So therefore, if it's the violations to the estate of my father, then they were supposed to provide notice to the estate or the administrator or someone that was deemed as someone sufficient as an heir to take that notice and be responsible for it. Freedom also asked for us to provide them with the death certificate. Upon providing them the death certificate, we were blocked from everything. So Freedom explained to us that, yeah, give us the death certificate, and then, you know, you'll be able to pay, you'll be able to, you know, address the account, you know, whatever deficiencies are there, you'll be able to do it. Once we sent them the death certificate, they shut us totally out. It's impossible to keep a mortgage current, to pay for a mortgage, to address the deficiencies for an estate if the estate is not allowed to. So Freedom contends that, you know, there's no foreclosure, that there are no breaches of contract. There's a breach of contract to the estate just based on the fact that they blocked us from any access to the mortgage. Now, if you block us from access to the mortgage, then you have subsequently prevented us from paying the bill, which subsequently leads directly to foreclosure. So if you make it impossible, absolutely impossible to win or to save your property, or to have the ability to save your property. So what happens is, when my father passed away, he was a cornerstone, you know, of the family, and someone had to step in to take care of it. and Freedom prevented the family. And since I've become the official administrator, they have prevented me from having any access to curing this situation or to repair the deficiencies or anything. And then on top of that,
Quick question. Did you, I think this is probably outside of the facts, but it's outside of the court's consideration right now, but I am curious, did you ever, or did the estate ever make payments that were rejected by Freedom?
Yes, back originally when we were trying to make payments, Freedom literally did not accept any payments. And then once we were blocked out of the account, we couldn't make electronic payments. You got to remember, when my father, well, I'm sorry, you don't have to remember. I apologize, Judge. When my father passed away, it was in October of 2020. He secured the loan from Freedom on 8/2020. He lived for 2 months.
Right.
You know, even the question of his, because he was drugged out most of the time because he was extremely ill. So I'm having a problem with the note that he signed in the first place, because I know the level of drugs that he was taking because he was in extreme pain. And I know for a fact that, you know, I don't personally think in his right mind he would have signed that. So that being said, you know, we're going to move past that. But the estate has the right to address any legal and financial situations concerning the estate. And Freedom have absolutely prevented us from doing that. Even in for argument's sake, the 8 months I've been administrator, I have been denied the ability to legally take care of my father's estate. And that for a fact is a breach of contract, and it is illegal. And then when it comes to the violation of truth in lending, right? Defendant actions, including the failure to provide necessary disclosure notices, constitute violations of TILA 15 USC 1601 ed SEQ C. Jasinowski versus Countrywide Home Loans. As a result of defendant TILA violations, the estate is entitled to statutory actual damages, rescission of the mortgage transaction, and injunctive relief. Now, since my father passed away on October of 2020, and the estate took over, when Freedom filed the foreclosure, it belonged to the estate and not to my father. So Freedom has the responsibility to provide the estate with whatever documentation is necessary, with whatever notices are necessary, and that not at any time has Freedom ever given notice to the estate.
So, Mr. Griffin, so my understanding, and granted, I'm a state court judge, not a federal judge, so I don't deal with TILA as frequently. But I will say my understanding of the Truth in Lending Act is it is about providing the person who's accepting the mortgage, or actually granting the mortgage, but in any event, it's about the individual who is undertaking this large obligation, right? Which a large mortgage that someone is undertaking, being provided with good faith disclosures about here's how much money it's going to cost you, here's where your money is being spent, all those things. And so Freedom's argument is that any obligation that it would have under the Truth in Lending Act was an obligation to provide your father with accurate disclosures about the mortgage that he was about to undertake. And there's no argument or indication currently that they didn't provide that information. And that obligation. So the reason I stopped you, Mr. Griffin, is that the notices and argument that you're talking about are, it might be an obligation that Freedom Mortgage has, but it's not an obligation that occurs under the Truth in Lending Act, right? And even if it did, the claim, right, usually a Truth in Lending Act has to be brought within a certain time period. That's what Mr. Badia is arguing, is that the time period for you to have asserted that has passed because it was about the obligation to make disclosures to Mr. Your father prior to undertaking the mortgage or at the time of undertaking the mortgage and not subsequently. Now, Freedom may have legal obligations under other statutes, other law to provide someone with notice. But I think their argument is that the truth in lending issue is associated with those notices on the front end and not necessarily to you subsequently. Does that make sense, Mr. Griffin?
Yes, ma'am.
Okay.
But also on that note, based on the fact that my father was under extreme duress because he was in the process of dying and he was also extremely drugged, I'm challenging that because I don't believe that he would have signed that mortgage knowing what I know now. And I need to
respectfully, Mr. Griffin, I understand that, but that issue is not asserted in your complaint, right? There's no argument in the complaint that you've raised so far. There's no assertion that I saw that someone exercised undue influence or that Mr. Griffin's signature on those documents was not accurate, wasn't his signature, et cetera. And so I do want to kind of keep us off of that issue because I certainly understand why you would be so. I understand why that would be upsetting to talk about and think about, but right now it's not presented to the court in the issues that are before me today.
Yes, ma'am.
Okay.
So in reference to count number 4, the violation of fair debt collecting practices, defendant actions including the initiation of a foreclosure proceeding without proper notice, the refusal to accept payments from the estate, constitute violations of the FDCPA 15 USC 1692 ET SEQ, see LeBlanc versus Unifund CCR Partners 601 F.3D 1185 11th Circuit 2010. As a result of defendants' FDCP violations, the estate is entitled to statutory actual damages as well as injunctive relief. That is our position. On count number 5, violation of Georgia Fair Business Practices Act, defendant actions included the wrongful foreclosure and refusal to facilitate emergency pandemic relief programs, constitutes unfair and deceptive acts and practices in violation of the GFBPA OCGA 10-1-390 SEQ. As a result of defendant GBA violation, the estate is entitled to injunctive relief. Now, in reference to that, Your Honor, when my father passed away, we were in the middle of a raging pandemic. The courts were closed.
No, they weren't. I'm sorry. I apologize, Mr. Griffin. I have to get back on you because I was here all the time. One of the reasons that we have hearings on Zoom right now is because we developed this process during the pandemic so that we could still, because Georgia courts are constitutionally obligated to be open.
Really?
And so with the exception of a very brief moment, right, at that March the 13th, when everybody was sent home by emergency declaration,
Yes, ma'am.
the courts have been open, accessible, and filing has been able to be accomplished, sometimes not easily, but I am going to push back on you a little bit. We were here and able to process cases, sometimes slowly, but we were here. Go ahead, Mr. Griffin.
Yes, ma'am. Thank you for that clarification. I appreciate you. Okay, so, but under the fair debt practices, Freedom has a responsibility to the estate to provide us the ability, right, to pay the loan, to provide us the ability to address all the legal ramifications of having a mortgage. And by completely blocking the estate from attending or curing or accessing programs that were available, they have deprived us of the ability to not only maintain our property, but also all of the economic benefits that come with owning the property. Okay, let me see. Count number 6, discrimination under the federal and state laws. Okay, Freedom, I'm an African American. right? And as an African American, I find it's unconscionable that I have asked for my rights to be acknowledged and for my rights as the administrator to be allowed to be able to save my father's property for his estate. And they have totally blocked me out. And I find that that is just unconscionable, not to mention it's against the law. As the administrator, I'm supposed to have access legally to everything concerning this mortgage, especially since the property is located in Georgia, in Fulton County. So, and I live in Georgia also. So we feel that we have been discriminated against, and we also feel that this has not been done to other people in the same situation. Now, my family's in contact with another African American that the same exact process was done to them. Parent was lost. They tried to take care of the account. Freedom blocked them out and then filed foreclosure against them. So we're trying to get them to come forward, you know, be a witness, sign documents. But this is not a one-off with Freedom. And based on Freedom requests that you ignore all the previous violations and all of the mortgage abuses they have been adjudicated and found guilty of, and all of the fines and all of the hold on one second, Your Honor. Just give me one second. Let me see what that document is. And I will be able to provide to the court where the Freedom sent and provided the federal court with the statement that they were only putting the mortgage on hold, but the mortgage was in full effect, and it will be one second. So Freedom wants Your Honor to ignore the fact that federal agencies have filed complaints and successfully convicted and or reached an agreement with Freedom about mortgage abuses. 2016, they had to pay a couple $1 million for that. More mortgage abuses. 2019, they had to pay a couple $1 million for that. Kickback and bribery from 2023 that the CFPB found that it adversely affected African Americans. They have a plethora of illegal activities in reference to the fair, in reference to the, I ran out of space, Your Honor, for all these documents. I apologize.
I understand. It's fine.
Fair debt collection practices. So Freedom has been considered by the CFPB as a habitual violator of the law. And also they have been found guilty on numerous occasions for intentionally misrepresenting and lying to the court. So the only thing that I am concerned with is the fact that Freedom wants to have this dismissed, because I believe that if this is looked at under any of these counts, you know, and I'm not an attorney, you know, I've had to do over 2,000 hours of research and filing. I filed so many motions and responses in federal court. Like, we went from state court, so I had to learn a lot about how to do it in state court. Then they put it in federal court. Then I had to learn a whole different set of rules for federal court. And then it was put back in state court. So it has been absolutely extremely challenging, you know, for less of a better way to express it.
I will say, Mr. Griffin, you've done an admirable job, especially for a non-lawyer. So You, I think are doing a fine job in trying to represent your family's interests. So,
Thank you, ma'am.
Now,
also, I would like to state that Freedom, these guys are well-financed, very established. They're professionals. So Freedom complains about my deficiencies, but on March 8th, defendant filed he filed an answer.
Oh, okay.
And then a few moments later, he filed an amended response. He found a response, and he filed an amended response. I got when I downloaded, I thought it was just one. I didn't even know that he filed two back to back. I had no clue. So, it's like it was a little confusing. And I would like to submit to the court that the deficiencies within my pleading, I would like to have the opportunity to correct whatever deficiencies there are and have a final submission for it, because it's like I've been bombarded with so many motions from defendant, and defendant knows that I'm not an attorney. So basically they just wanted to drown me in paperwork with the hopes of, having this dismissed without actually looking at the factual evidence of the case. But at the end of the day, it just comes down to one thing. You cannot block an estate from legally dealing with the legalities of its responsibilities in reference to property, mortgages, and preventing them from actually fixing or remedy any problems that have arisen after the death of the original owner. It is absolutely illegal.
I understand, Mr. Griffin.
Yes, ma'am.
Thank you so much for your presentation. I have a couple of questions, and then I'm going to give Mr. Badia an opportunity to respond. Mr. Badia, you mentioned that the court could properly consider the contract because it had been referenced, and clearly it's referenced. I don't see it attached anywhere. If it is attached, I've just overlooked it. And if you could direct me there. If it's not attached, I think I would like to take a look at it, because I do think it's fair game for purposes of understanding the nature of any obligation that Freedom Mortgage did or didn't have that might transfer to the estate.
Yes, Your Honor, it was attached. It was attached to our amended answer. We had filed an answer that frankly was supposed to have it attached, and because of a clerical error, it was not. So
Are
we
we
filed.
talking about docket 16 that you filed on March the 8th?
Yeah, hold on, let me make sure I get it right here. No, the answer itself. So we initially filed on February 12th.
I see, on the 15th.
The 15th is the one, correct, Your Honor.
Okay.
The amendment that's on February 15th. That has the security deed and the promissory note attached to it. Thank
you. I appreciate that. And then my next question, Mr. Badia, is what is the status of Freedom Mortgage's efforts to perfect its right to foreclose?
As far as I understand, everything is being held in part because of the bankruptcy and also because of this litigation. As far as I understand, no foreclosure is moving forward. Certainly, as Your Honor pointed out before regarding how things are done in Georgia, there are legal notices that have to be sent out, right? That have been published. Those have not been published. And so there is no pending foreclosure sale.
Okay. Okay. That's what I think you've sort of halfway answered my question, but let me ask a follow-up. I certainly already understood that there is not an actively pending action for foreclosure. But I guess my question is Freedom Mortgage, are you of the opinion, or because Mr. Griffin has pointed out that the representation has been made that the foreclosure, whether it was by you to the federal, by your client to the federal court, or whether it was by the employee that Mr. Griffin spoke with recently, that the foreclosure is there, but it's on hold. So I guess my question to you is, if Freedom were to decide that it was ready to pursue its foreclosure rights relative to this property, what is the status of what Freedom Mortgage would have to do next? Or is it of your opinion that they would essentially have to start over again with those notices, et cetera?
I don't want to speak out of turn, Your Honor. And first of all, my apologies if I didn't answer your question the first time. I don't want to speak out of turn. We would not, our firm would not handle that
Right.
foreclosure process. But my understanding is that under Georgia law, if Freedom wanted to pursue a foreclosure sale on a date certain, it would have to, at a minimum, resend foreclosure notices, republish foreclosure notifications in the legal organ.
Right.
I don't know about what notices would go directly to the borrower. I don't want to misrepresent what that is because
No, I understand. Okay, thank you. Okay, so those were the two questions that I had. Yes, sir, Mr. Griffin?
Okay, so the property was going to be sold on March 4th on the steps
Of last year or of this year?
of last year.
Of 2023. Okay, go ahead, Mr. Griffin.
So all the notices and everything went out, and there were publications, and Freedom went through the entire process
Right.
to the sale, right?
Yes, sir.
Freedom was responsible to make notice to the estate.
Yes, sir.
And therefore, what this is about presently is Freedom's previous violations in reference to the estate. How are you going to sell a property when you have not noticed or provided the estate any opportunity whatsoever to address your actions or to address the deficiencies or to assume, like, the estate was provided no opportunity. So basically Freedom went, we're taking the property, we're not going to acknowledge any of your rights, and there's nothing you can do about it. If it was not, and we pursued and we called them, we sent them emails, we tried to contact them, and we found out that their corporate office was closed and that most of the employees were working from home. And the offices that they had in Georgia were all closed. So we didn't have any access to any offices or anything. And since we didn't have access to them mailing us anything or providing us documents or anything, they are in total violation, because even though they were not able to sell the property based on the bankruptcy, they still went through all the processes to do it. And if it were not for the bankruptcy, they would have sold the property.
Right. And so I understand that, Mr. Griffin. And the reason I asked those questions of Mr. Badia, and the reason I keep both of you having discussions with both of you about where is the status of the foreclosure and what's required, is the reason that Freedom's argument is that we haven't actually foreclosed, right? We haven't actually undertaken, even if we came close. And the reason I asked to confirm that Freedom would need to undertake that at least publication process and probably notice process again before it could get to a foreclosure is that the reason a cause of action for wrongful foreclosure exists is because the damage that has occurred, right, the wrong that has been visited upon the person who's been foreclosed, in your case, the estate, is the foreclosure. And so the idea is that if the property hasn't actually been foreclosed, or they're not actively in the process of foreclosing, then even though you're frustrated by the lack of an ability to work with Freedom Mortgage or to access the systems that they use, the idea is there's been no wrong because there's been no foreclosure yet. And so that's their argument about why there's not a cause of action for wrongful foreclosure, number one. And number two, that's why I keep asking questions about what would be their obligation if they were to try to foreclose. And the reason is that if they go forward with a further effort to foreclose, then you would again have the right to raise that issue and say, okay, now they are trying to foreclose and this is wrongful because they haven't done it right. And so that's why I keep asking those questions.
Okay.
But thank you. Yes, Mr. Griffin?
But the estate has suffered substantial losses based on the fact that we had to go through this foreclosure process. Freedom is famous for adding ghost fees and amounting like hitting properties with a lot of charges for a lot of different things. So Freedom asserts that they haven't done anything wrong, but if they have added all kinds of charges, all kinds of fees, all kinds of legal costs to the property in the process of the foreclosure, then harm has been done to the estate. Like, for instance, just a rough estimate, Freedom alleges that they haven't done anything wrong, but over $73,000 has been added to the cost of the mortgage. So
Okay.
I believe that
I-
the discovery.
I understand, Mr. Griffin. I do, and I don't mean to cut you off. Because again, I feel like part of what's happening here is that if and when I think, and I'm only speaking about the wrongful foreclosure claim that you have asserted in count one. I think that the issue here is that if and when Freedom reinitiates those efforts to foreclose, then you would be able to say this is wrongful and here's why. And all of the things that you're trying to argue to me about how they didn't give you notice and how they accelerated things and how they they blocked your ability to pay, right? Those would all be things that you would bring to the attention of the court at that time. I know it's frustrating, but I think the issue is currently, as to the wrongful foreclosure action, is that I can't say that there is a cause of action for wrongful foreclosure when legally there is not currently an action to foreclose. Now, there may be in the future, there may even be in the immediate near future. But you would receive notice of those things and be able to undertake to vindicate your rights when that happens. That's the part. I know it's frustrating, but it's sort of like our causes of action are little boxes and you have to sort of fit all of the things into that box. And right now your claims are not inside that box because there's no foreclosure. Your claim for wrongful foreclosure. Yes, sir, Mr. Griffin.
So would I be able to amend my pleading?
Well, let me hear from Mr. Badia and let you know what I think I'm going to do, and we can talk a little bit about that, Mr. Griffin. Mr. Badia, it is your motion, so I wanted to give you an opportunity to respond briefly on the issues.
Very briefly, Your Honor, and thank you. I appreciate the court's patience with us and being generous with the time. Just a few points, and I'm going to start with one factual issue only because it was raised by Mr. Griffin, and then I'm going to stick purely to legal arguments. Just as a factual issue, Your Honor, a couple of factual issues. One is, putting aside what happened, Mr. Griffin continues to say it's illegal to block the estate. It's illegal. It's illegal. He has not provided any authority, whether under the contract or under some statute. And I'm not saying that to say Freedom absolutely can do whatever it wants and block. The point is, Your Honor, as a context, and I agree with Your Honor's statement before that this is outside the scope of this motion, but there is a process that needs to be followed. If Mr. Griffin just calls up Freedom and says, I'm now the administrator, Freedom cannot act on that. There are legal processes that have to happen. And I'll just leave it at that. Second, as to the well, just quickly, just on the cases that Mr. Griffin cited, the Heritage case is clearly distinguishable. There was a foreclosure sale, which Your Honor has gotten into at length, so I'm not going to get into that. But here, there's no foreclosure sale. That is the legally significant point for a wrongful foreclosure claim, as made clear in the cases that we've cited. There's no foreclosure sale here. There's no wrongful foreclosure claim. In regards to LeBlanc, which Mr. Griffin referenced, completely distinguishable. That's a debt collector who was trying to collect a consumer debt, has no bearing on the issues here. As to the FHA issue, Your Honor, Mr. Griffin has not come forward with, at this hearing or in his complaint, with any evidence or allegation even. And again, we're not looking at evidence, right? I agree with Your Honor. We don't want to get into evidence at this point because this is purely a pleading stage. There is no allegation that Freedom has done the things that he talks about in his complaint. And to the point of avoiding, which I had mentioned before, we're not trying to avoid. What I'm trying to avoid is having the court convert this to a motion for summary judgment, because that is not Freedom's intent. We want to remain at the pleading stage at this point. But the last thing on that point is even if the court were to look at what Mr. Griffin has cited, none of that has anything to do with the claims that he's made as to how allegedly maybe certain people in Fulton County have been discriminated against by Freedom. So I'll just leave it at that. And one other thing that I forgot to mention at the end of my presentation, Mr. Griffin, on the breach of contract point, Mr. Griffin in his response cited two cases, two 11th Circuit cases, I believe. I have not been able to locate those. I don't know if there was a typo or something, but I don't know if those cases exist or not, but I was not able to find them, and so I can't respond. And so I think, just to close it out, Your Honor, we don't think there's any relevant fact disputes here. I think all of this are legal matters that can be decided by the court at the pleading stage. One other point I just wanted to make as a factual point that is in the record. Foreclosure sale was noticed in March of 2023. Mr. Griffin said that Freedom was required to provide notice to the estate at that point. He was not the probate order that he submitted in this case and put as evidence, or excuse me, as an attachment to his answer, shows that he was not appointed until September of 2023. So factually, the timeline doesn't add up there. And so I'll just leave it at that. Again, don't want to get into factual disputes, but as a timeline matter that is in the record, the foreclosure sale was originally noticed in March 23. Mr. Griffin was not appointed administrator until September of 23. And so unless the court has further questions, I'll stop there.
I do not have any further questions. Mr. Griffin, very briefly, sir, because technically Mr. Badia is entitled to the last word, but go ahead, Mr. Griffin.
Yes, ma'am. At that time, I was appointed as a temporary administrator of the estate. And
Okay.
and regardless of whether I was or not, Freedom is still obligated to notice the estate of his actions.
Okay. So I suspect, though I've not read the contract, that Freedom's obligation is to provide notices to the holder of the contract, probably at the residence address of that person who, in this case, it's not always the case, but in this case, probably was at the address to which the mortgage applied. And so whether Freedom had an obligation to notify the estate or you personally, I suspect that Freedom was obligated to notify the mortgage holder, and that notice would have been mailed or otherwise provided to the residence address, the mortgage address. I don't know that, but I suspect that is what would likely have happened here and likely is intended to happen. So here is where I'm going to leave it. And to Mr. Griffin's question about whether he can amend his pleading. Here is, I think it's important that this is not a motion to dismiss, right? We're here on a motion for judgment on the pleadings, which is slightly different, but the standard for it is important here for a couple of reasons. So let me start with the easiest things. Number one, Mr. Griffin, I understand your frustration with all of this process, but what I'm going to tell you is that legally Freedom is correct that there is no foreclosure action, and therefore there cannot be a wrongful foreclosure action currently. That doesn't mean that when one is undertaken, you cannot pursue a wrongful foreclosure or pursue an injunction to try and stop such wrongful foreclosure once it's initiated, but there isn't one pending. And so there is no legal basis for you to assert a wrongful foreclosure. That's number one. As to counts 3, 4, and 5, Freedom is also correct that truth in lending action is either or both time barred, or it does not apply to the circumstances before me. And as to counts 4 and 5, which are about wrongful debt collection practices, those causes of action are typically understood to apply to third parties attempting to collect a debt, not a debt holder attempting to recover on their own debt. And And even if that was done, typically the wrongful actions that are to be vindicated in those types of causes of action are about harassing phone calls and inappropriate contact. And what I'm hearing is the exact opposite of that, this argument that there was no contact or not appropriate contact. The breach of contract issue, I am going to leave open for now. And the reason is to the question that I asked a moment ago about where the contract is. I've now been able to locate it as a part of document number 12, which was defendant's amended answers. It was filed as an exhibit to that. And I think it would be appropriate and acceptable for the court to look at it and consider its terms because it was directly invoked by the complaint and has been attached for the court's benefit by the answer. And so the reason I want to take a look at that is, as I was explaining to Mr. Griffin, to the extent that Mr. Griffin has alleged a breach of contract, what I want to do is look at what were the obligations that Freedom had to Mr. Griffin's father and look at whether it's been alleged that Freedom breached those duties, which would be available to be vindicated by the estate if such a breach occurred. So I want to take a look at that and provide a ruling after I've had a chance to look at that in more detail. As to count 6, Mr. Badia, I agree with you that it's real vague. I agree with you that it may not apply here. But I'm not sure it's appropriate for a motion for judgment on the pleadings adjudication. Because even on an MJOP, I'm still supposed to give the benefit to the pleader. And there is the allegations, if believed true, I think at least open something up, although they're vague. And so, Mr. Griffin, to your point, I think my intention is to ask you, I'm going to dismiss or grant the motion for judgment on the pleadings as to counts 1, 3, 4, and 5. So that's the wrongful foreclosure claim, the truth in lending action, the Fair Debt Collection Practices Act, and the Georgia Debt Collection Practices claims. As to the breach of contract action and the Fair Housing Act claim, Mr. Griffin, I'm going to give you an opportunity to amend your claims for counts 2 and 6 and give you an opportunity to allege with more specificity what it is that you allege that Freedom Mortgage, what duty or et cetera you allege Freedom Mortgage breached under the contract. And by that, I mean, I need you, if possible, to at least provide notice, because that's the standard notice pleading, to help the court understand and so that Freedom Mortgage can respond to what it is that they are alleged to have, what wrongful act they're alleged to have committed. And then specifically as to count 6, I do have concerns that it is too vague. And so to the extent that you can provide the court with a better understanding of what is the nature of the wrong that you believe that Freedom Mortgage has committed under the Fair Housing Act, because the purpose of a pleading is to put Freedom Mortgage on notice of what it is you believe that Freedom Mortgage has done that would be a violation of the Fair Housing Act relative to Mr. Griffin and or Mr. Griffin's estate. And that's not present in the complaint, but there's enough there that I think I'm going to give you one opportunity to provide more detail. And then upon having that additional detail, Freedom Mortgage will be given an opportunity to respond and take whatever motion action they wish to. And then we will meet again. So what I'd like to do today is, so first thing, Mr. Badia, I'm going to ask you to provide the court with a proposed order. If you'll do it by email and copy Mr. Griffin so he can see it. The purpose, Mr. Griffin, of you seeing that proposed order is not to re-argue the issues, but to make sure that you don't have an argument that the order he's presenting is not what I've said here today, right? That he's presenting some order that doesn't accurately reflect my ruling, which I'm giving right now. And that ruling is going to be that I'm granting Freedom Mortgage's motion for judgment on the pleadings as to counts 1, 3, 4, and 5. As to counts 2 and 6, I am requesting that the plaintiff provide a more definite statement as to counts 2 and 6. And Mr. Griffin, is it reasonable? So as we sit here now, it is the 4th of April. If I were to give you until the 18th of April, that's 10 business days, and it's roughly 2 weeks. Would that give you enough time reasonably to amend your complaint to provide some more detail?
Your Honor, we just had a death in the family and a hospitalization of the matriarch and another person that is extremely important to the family. And I'm kind of responsible for taking care of circumstances and situations. I would like to request preferably in the first week of May. I should be able to take care of it by then, because right now I'm slightly overwhelmed, and there's a lot of moving parts to losing family members, and it needs to be addressed. And then as my father's replacement, I'm responsible for a lot of things and several people.
I understand. And first of all, Mr. Griffin, I don't know that I've said it before now, but I am very sorry for your family's loss. Even 4 years ago, I know it can be hard, and especially that your family is still experiencing that additional loss with other family members. So I'm very sorry of all that you're having to deal with. It is a little longer than I'd like, but I given what you're dealing with, I think I will give you that additional time until May the 2nd, which would be a full month.
Yes,
And then once that additional information is filed, the more definite statement as to counts 2 and 6, we will go from there. For now, so the order will say the ruling I've made on those counts, and then as to 2 and 6, that Mr. Griffin is to provide a more definite statement as to counts 2 and 6 no later than May the 2nd. And then the last thing I will say is Mr. Badia, I'm done with my ruling. That's my whole ruling for today. But Mr. Badia mentioned that he thought there had been some settlement negotiations. Mr. Griffin sort of very forcefully pushed back against that, saying there'd been an offer made, but not really anything that was acceptable to the family. I would just like to encourage, I generally don't require a mediation until, well past where we are now. But it seems like this is something that could be potentially resolved between the parties. Because I will say that, in my experience, whether it's me making the decisions or a jury making the decisions, at the end of the day, when y'all negotiate and settle it, you might not be all the way happy, but at least it was your decision. When I make the decisions or when a jury makes the decisions, it's entirely their decision and you're just stuck with the outcome. And so I would really strongly encourage the parties to see if there's something that can be worked out here. Not ordering you to do so, but I am encouraging you to do so. Also, just remember there is as well pending a motion for stay regarding discovery in the action. And I am going to grant that motion until after the court rules on after the court receives the additional more definite statement as to counts 2 and 6, and then whatever motion practice we might need to undertake. And so for now, I am going to stay discovery in the case until probably mid-May, once we get an idea of what motion practice we're going to have based on Mr. Griffin's additional information that he's going to provide to the court. anything else that I need to address or take up for right now in terms of the motions that are currently pending and the ruling that I've just given? Mr. Griffin?
Yes, ma'am. In reference to my initial pleading with the injunction against freedom for foreclosure.
Yes,
right?
sir.
Because I was advised by the actual freedom that they were going to proceed on May 31st.
Okay. And so if and when you receive a notice that they are intending that they're proceeding,
Yes.
then you would be free to seek whatever relief that you believe is appropriate. The reason I'm speaking very vaguely, Mr. Griffin, is that two things are here. One is I'm not allowed, because you are pro se, I'm supposed to treat you just like any other lawyer. Even though I understand that you're not, but I am not supposed to give you special help. And most importantly, I'm not allowed to give you legal advice because I'm the judge here. And so I can't tell you what you can do, what you should do, what you might do, except to tell you that I'm always a big fan of people getting lawyers, which I know are expensive and sometimes it's not possible. But in any event, what I can tell you is that relative to, there is nothing for me to currently enjoin, right? Because there is no action that is currently being taken. Legally. If at some point that occurs, as I've already said during this hearing, you would then be in a position to request that the court undertake, give you whatever relief you think is appropriate relative to them undertaking and acting upon taking steps toward that foreclosure, if that's what happens. Do you understand?
Yes. Yes, ma'am.
Okay.
And I'm
Anything-
appreciative for your information and
Okay.
Statements. Thank you.
Thank you, Mr. Griffin. Mr. Badia, anything from Freedom Mortgage before we adjourn?
The only question I have, Your Honor, is just when you would like the proposed order by?
A week or less, like today is Thursday, right? So a week from today, if that's doable.
Do we have till the 12th, Friday? Just because I've got some depositions early in the week next week.
Sure, that'll be fine. Friday the 12th.
Yes.
Okay. Yes, Mr. Griffin?
In reference to me having access to my father's accounts and stuff with Freedom, is that something that can be addressed now?
So I'd like for, I am not in a position to order any such relief because there's no request formally for such relief pending in front of me right now. However, what I would like is if Mr. Badia, are you in a position to talk with Mr. Griffin offline about what needs to happen to enable him to speak to Freedom if he is able to, given that there is ongoing litigation about, as the estate representative, about the current status of the mortgage?
I don't know. I mean, I will say, Your Honor, I believe I have given that information to Mr. Griffin.
Okay.
If he disagrees, we can have another conversation and
Okay.
we can discuss that further. Again, I don't want to get into settlement discussions, but
I understand.
as Mr. Griffin mentioned, we had made an offer and there was no response, but I'm happy to have another conversation about those issues with Mr. Griffin, and we've kept the line of communication open.
Okay. Well, Mr. Griffin, I would suggest to you that you reach out to Mr. Badia and see if you can find out what would be required to allow you access and what that access looks like. I mean, I know as a practical matter, right? A lot of people access their mortgage stuff online, and I know that frequently that access is removed when the principal is no longer alive or able to access it. And so that may be part of your frustration. I don't know. But I will simply say to you that I would suggest that you reach out to Mr. Badia about how you could go about obtaining access and getting the information that you need in terms of access, if that's possible. And they may say that it's not possible, and then we can have a different conversation if there's one that we need to have at a later time. But that's unfortunately about all I can offer you at this point, Mr. Griffin. Okay.
Yes, ma'am. Thank you.
Okay. Thank you all for your time. I appreciate it. And I will look for your order on the 12th, and I will get that order on file and then look for Mr. Griffin's amended pleading on May the 2nd. Okay. Thank you all. Have a good day.
You too. Take care.
Okay, I think I see Mr. O'Brien. Hi, Mr. O'Brien, how are you? Sorry we
Hi.
had to track you down.
Oh, yeah, I very much appreciate that. I calendared it at 10 o'clock and I have no idea why. I'm so sorry.
No worries. Well, it's after 10 now, so you're on time. It's
Yeah.
like you were here the whole time, Mr. O'Brien. Let me, if you guys don't mind, I finished all my coffee. Let me go get some more coffee and then I will be back with you in just a moment. Okay?
Your Honor,
Great.
if I may,
Yes,
I'm
Ms.
still
Gardner.
waiting from American Express versus
Oh,
Regina
yes.
Howard.
Thank you, Ms. Gardner.
I have another hearing, so
I appreciate your patience. It is 10:48. The hearing was scheduled to begin at 9 a.m. It is clear to me that Regina Howard is not going to appear. And I believe that this calendar was noticed with an indication in the notice that failure to appear could result in a striking of pleadings, et cetera. And so if you want to submit to me, Ms. Gardner, an order striking a proposed order striking Ms. Howard's answer. And then accompanied by that, a motion for a default judgment based on the fact that there is no answer. Then the court will take both of those under advisement and get them on file for you, assuming that they are in order as quickly as possible.
thank you, Your Honor.
Thank
May
you,
I
Ms.
have
Gardner.
excused?
Yes, ma'am. Okay. Okay, give me 2 minutes and I'm going to come right back with fresh coffee and we'll get started. Thank you.
Thanks.
Okay, I'm back. Thank you for your patience. Okay. Madam Court Reporter, are you ready to get started?
Yes, Your Honor. Thank you.
Okay, no problem. So this is going to be a hearing in the matter of Disma King, that's DISMAH, versus Greenbrier Marketplace, the second LLC. Case number 2023 CV 380268. I'll note for the record that I have Mr. Jim O'Brien here on behalf of the plaintiffs, and then I have Ms. Yamisi James and Corey Wagner here on behalf of Greenbrier Marketplace. Also, in the interest of full disclosure, it's funny that I tripped over that word, but I think at some point I may have actually represented Greenbrier Marketplace about 8 or 10 years ago in some sort of case when I was a private attorney representing Lewis. I worked at Lewis Brisbois. I don't think that it matters, but I thought I would mention it. I don't have any recollection of anything that was involved in the case other than the name of the entity. So I just wanted to make sure that y'all were aware of that. And go on from there. So the reason that we're here today is on a motion for summary judgment that was filed by the defendants, based in part on deemed admissions, but also substantively based on some of the nature of the allegations. And so I wanted to hear from the parties regarding the substance of the case. And I think what I want to start with, because I think it will inform the nature of our discussion, is to start with plaintiff's motion to withdraw the deemed admissions. And then, because as I have read the summary judgment motion, even if the court were to allow the admissions to be withdrawn, there is still a substantive summary judgment that we need to deal with in terms of the defendant's position that they're entitled to summary judgment on the claim, even if the admissions are not deemed, even if the requests were not deemed admitted. So with that general understanding, Mr. O'Brien, I'm going to ask you to address your motion to withdraw the deemed admissions, please.
Yes, thank you, Your Honor. Pardon me. I think probably the best place to start is just with a couple of real honest factual statements about how this came to pass that we did not respond to the admissions. And the first thing to clarify is that when this case was first filed under the initial filing a few years ago, we responded fully to the discovery, including to a set of admissions. And then it was dismissed and refiled. And as I understand the allegation is that several attempts were made to contact my predecessor to ask him to just consider all the prior discovery applicable to this case. And for whatever reason, that was never done. I mean, he never responded. The fact is, though, the new requests for admissions are the ones that are being deemed admitted or would be deemed admitted are identical to what we answered before. And I think that really goes more than anything to prejudice. It's not a case where we didn't respond to discovery or where the defense didn't have information. They had a full set of discovery, but by, I guess the mistake on our side, we didn't enter that agreement to have them count in this matter. So probably just as a functional argument, the court's interested, of course, in justice and not wasting time. But what we're asking for should have been done on our side with that agreement to just count them as applicable to this case, as we pretty much always do when we have a dismiss and refile.
Okay.
Okay.
Go
So
ahead.
I mean, obviously, you know, I'm not going to read the case law or the brief to you, but I just really wanted to have that context that we're just talking about something that's, you know, handled in the prior case and should have been handled better in this case for sure.
Okay. Thank you, Mr. O'Brien. Will I be hearing from Ms. James or Ms. Wagner?
Hearing from me, Your Honor.
Okay, Ms. James, go ahead.
So with respect to the request for admissions, if the defendants did not reserve discovery, then nothing would be binding. And we made efforts to have the prior discovery responses on a few different occasions with plaintiff's counsel to enter a stipulation to avoid going through this. So this was not a case of trying to play gotcha or anything like that, but to simply preserve the defendant's rights to seek written discovery in this new case. Based upon that, the plaintiff has to show two elements in order to have these admissions withdrawn, and they have not been met here. I understand the sort of justice argument that Mr. O'Brien is making, but the requirements that need to be met need to establish, one, that there is some sort of evidence that plaintiff is pointing to show that the admissions are not really credible, and then a lack of prejudice on our part. If the first element has not been shown, then you don't get to the second element. And I don't see where there has been any type of credible or admissible evidence that would allow Your Honor to even get past the first element. Even assuming that Your Honor did find something with respect to the second element, there has been case law that we've cited in our response that shows that if we rely on these admissions, and as they've been relied upon in our motion for summary judgment, or when a party is not seeking to move until after the expiration of the discovery period to withdraw those admissions, that is prejudice to the defendants. So on that basis alone, based upon the actual legal requirements, we don't see how it would be possible that the admissions should be withdrawn, just based upon the legal standards.
Okay. So Mr. O'Brien, let me ask you to address the specific. So most of your, as Ms. James pointed out, most of your presentation was focused on the argument that there's not prejudice here to the defendants for the withdrawal of the admissions. But I guess her point is that to get to that point, you need to be able to demonstrate that the admissions don't really, that they're not actually substantively tied to what the facts in the case are. And I don't know that you really addressed that issue. So if you want to try to address that issue a bit.
Well, I think, and as I've understood the case law, when it comes to that point, it's about that whether the admissions are, I'm trying to find the right word, but sort of the only evidence
Yes.
on an issue. Okay, so they're not, the ones that are deemed admitted are not the only evidence on the issue, because all our prior discovery requests, like our responses to the request for admissions and the RPDs and the interrogatory responses, are a body of evidence that is established. Now, again, we made the mistake of not entering that, not even responding to the request to have that all apply to this case. That was a mistake, but that is all evidence that is out there, even if we didn't lock it into this case, that is that the deeming these new ones admitted would be a complete contradiction to that existing evidence. So that alone is just a body of evidence that is very accurate and very much about the case, based in reality, not based in just deeming anything admitted.
Okay.
So yeah, that prior thing, actually, it ends up applying both prongs. That both the credible evidence prong and the prejudice prong is the fact that all that discovery was done before.
Okay. Okay, so I had reviewed the briefing. I don't know, even though I knew that it was a renewal action, I don't know that I was as clear on the full scope of what had occurred in the prior action before it was dismissed. And given what I understand, which was that more fulsome discovery occurred in the prior action, that I think I'm satisfied that the plaintiffs have met the standard that they need to satisfy to demonstrate that the request for admission should be allowed to be withdrawn, or the deemed admission should be allowed to be withdrawn. I will also note, just to make sure I'm right, that on February the 21st, docket number 29, the plaintiffs did provide actual substantive responses to those requests. Is that correct, Mr. O'Brien?
Yes, that's right, Your Honor.
Okay. And so for that reason, I am going to grant the plaintiff's motion to withdraw their admissions and allow the admissions that were filed on February the 21st to stand as the answers to those admissions. So with that, I am now going to turn my attention to Ms. James and ask you to please present regarding the summary judgment motion that your clients have filed, mostly focused on the association, the relative interest or right to control possession that your clients had relative to what was going on at the time. I think that's what I understand, along with some other issues. So please go ahead.
And I just also want to note, Your Honor, that we also represent the defendant Albert Escudi in addition to our marketplace. So yes, Greenbrier Marketplace 2 LLC was an out of possession landlord. That is simply something that is undisputed. And we would refer, Your Honor, to the affidavit of Albert Escudi, which, describes the fact that they leased out to 2925 Properties LLC the entirety of the premises. It's undisputed that both Greenbrier and Albert Escudi were not under the control, possession, nor operation of this area on the date in question. There is nothing that plaintiff has pointed to that suggests otherwise. The plaintiff in their response make mention to the common areas. However, the common areas have no relevance to where the subject shooting took place. The common areas, as described in section 1.6 of the lease, identifies areas like the parking areas, access roads, landscaping, and things like that. This happened outside of a booth in the inside of the discount mall. There is nothing showing any relevance to the common areas as defined in the lease agreement to where the subject shooting took place. And Albert,
Right, but forgive me, but so two things I want to clarify with you. One is when you say the entire premises were leased to this other entity, I think I understand you're talking about the specific store or space that was being used where the shooting took place, correct?
We're talking
not the whole entire building or mall or whatever it is.
No, actually, the discount mall itself is
Okay.
to 2925 Properties.
Okay. And the second question I had relative to the common areas is who was in charge of the common areas? Was it Greenbrier Marketplace 2? Number one, and number two, I understand that the shooting may have occurred inside one of the stores, but that I think I understood some of the facts indicate that this was a series of engagements, albeit brief, some of which might have occurred inside the common area, or no?
No, Your Honor. So with respect to the common area, that is still still under the purview of 2925. But the plaintiff in their response had made reference to the fact that we could go in and have a right of inspection in the common area. And so then to your second question about where everything took place, that was all in the interior that was deemed a part of the leased premises, not the common area. And that's why in the affidavit, there's that distinction made there about, specifically the area where these events took place. That was not something that was under the control or operation of Albert Escudi nor Greenbrier Marketplace.
Okay.
And as a result of being an out-of-possession landlord, the case law is pretty clear that under OCGA 44-7-14, having fully parted with that area, the landlord is not responsible to third parties for damages resulting from the negligence or illegal use of the premises by the tenant. And in the Boone versus Utoto case, which we did cite to, the landlord, even assuming that the common area outside, as set out in the lease, was where this area took place, was where the subject incident took place, which is not, a landlord retaining the right for inspection or limited entry or things like that does not amount to the right of actual possession of the leased premises. And there is no actual evidence to suggest otherwise. With respect to specifically defendant Albert Escudi, and I don't believe that plaintiffs really contested this in their response, but he's not a proper defendant with respect to the premises liability because he himself is not the landlord or owner or operator of the area in question. That arguably, when you had the landlord Greenbrier Marketplace, and there you can have them, even though we dispute liability based upon them being an out-of-possession landlord, but Albert Escudi himself is not a landlord or someone who was in possession or control of the area in question.
Okay. Forgive me, Ms. James. Tell me again, what is Mr. Escudi's specific relationship to the premises?
Okay. Mr. Escudi is a member of Greenbrier Marketplace 2 LLC, and I will turn your honor's attention to Exhibit B to our motion for summary judgment, which has Mr. Escudi's affidavit. He is the partial owner of Tabas 2 LLP, which owns a portion of Greenbrier Marketplace 2 LLC.
Okay. Okay. Thank you.
The next ground that we move for summary judgment for, Your Honor, is under the basis of there being no evidence to show that these defendants should have reasonably, assuming again that we're keeping Mr. Escudi in as someone who might be liable under a theory of premises liability, that there was no evidence to show under a totality of the circumstances that these defendants should have reasonably foreseen what was going to happen at the time. What plaintiffs is seemingly offering up now are these this crime grid that was attached. But as Your Honor knows, there has to be more than that. There has to be something to tie that to the actual conduct of these defendants. There's been nothing to suggest actual knowledge of this. There has been nothing to suggest that any of these crimes that they're alluding to in the crime search are actually things that are such reasonably foreseeable that would make it reasonably foreseeable to these defendants. Anything about their similarity. We know nothing about these crimes that plaintiffs are presenting to suggest why there should be knowledge or liability on the part of these defendants. And that is even in consideration of the updated CVS Carmichael case. There's nothing to tie these defendants to these crimes here. It's not enough for plaintiffs to simply put up a document showing that there was crime within 2 years preceding, and that is enough to survive summary judgment, to show actual wrongdoing on the part of these defendants. Another aspect of this case, which I believe I don't think plaintiff is any longer contesting, but please correct me if that's not the case, are these claims of negligent hiring, training, supervision, and entrustment. Our defendants didn't hire anyone on these premises. There's no evidence that anyone was employed by our defendants, and there has been no one identified specifically that they are claiming that we negligently hired, trained, or supervised. So I'm not sure how those claims could survive. There wasn't any evidence pointed to in those, and I don't think there was any rebuttal in plaintiff's response. The security guard who was present, to the extent that plaintiffs are trying to claim that he was negligently hired or retained, our defendants had no involvement with the retention of the security services. That's something else that is also outlined in Exhibit B to our motion for summary judgment, that Greenbrier Marketplace nor Albert Escudi had any involvement in the hiring of security services of the security guard who was present there, to the extent that that is what they're trying to tie us to.
Okay. Anything else that you want to present for right now, Ms. James? Understanding that I will give you the last word after I hear from Mr. O'Brien.
The one last thing that I would like to touch on, because it seems plaintiffs were making a relatively forward argument with this, is the issue of being a mutual combatant. As you know, in order for the plaintiffs to recover in this suit, they have to show that we had knowledge superior to them. If Mr. King had knowledge that was equal to the defendants, then he cannot recover in this lawsuit. And I would turn Your Honor's attention to the Cornelius versus Morris Brown College case, which we did cite in our motion for summary judgments. Plaintiffs will argue the fact that Mr. King took in to intervene on behalf of someone else, of a employee at the discount mall who was being harassed or berated by the shooter, Nico Bell. However admirable that may be, the case law is clear that once you have knowledge of the fact that there is violence that is going to be imminent, or you inject yourself into a fight, that your knowledge is superior to that of the defendants. And in that Cornelius case, the quote reads, "Even when a person enters into an altercation with the purpose of breaking it up, the responsibility for any injury lies with the intervener. The superior knowledge must always remain with the combatants." And that is 299 Georgia App 83, a 2009 case. His knowledge is superior to everyone else. He has his own, during his deposition, on page specifically 94, when asked what he thought was going to happen, he testified, "I knew by then I was is he about to shoot her?" And when asked, "Did you think he was referencing a weapon when he was putting his hand in his pocket?" he testified, "Yes." And after you observed him putting his hand in his pocket, what happens next? "Well, I tried to de-escalate the situation." That is equal knowledge. That's superior knowledge to any one of the named defendants here other than Nico Bell. And that bars his recovery from these defendants as a matter of law. And I would just leave that with you, Your Honor, for now, and just have a little rebuttal at the end.
Okay, thank you, Ms. James. Mr. O'Brien?
Thanks, Your Honor. I think more or less going in the order that was discussed here. So the first thing I have is the right to control, and the lease document itself that the defense relies on says things that are very contrary to their position. First off, the definition of common areas includes walkways and public restrooms. Now, there's no allegation this happened in a restroom, but the significance is that theoretically walkways, and this is probably going well beyond what would be appropriate on summary judgment anyways, but you know, a walkway could be something outside or inside in a mall setting. But so the reason I highlight public restroom, well, that tells you that it's more than just outside. The common areas are more than just outside. It also, and this is laid out right in our brief, that they maintain more than just the right to inspect. And within their rent, they or within their lease agreement, they have the right to police the common areas without obtaining consent, to control, close, alter common areas. And then they even charge tenants for cleaning, policing of these common areas. Police the common facilities and common areas is a direct quote. Fire security and police protection. And so this is not a disconnected or absent landlord situation. The structure of their lease leaves it as a significant factual issue of whether they control the common areas where this happened, in particular, control the policing and security of those common areas. In fact, and this isn't precisely in front of your honor, but it's worth thinking about it. If their position that they don't control the common areas where this happened, you know, is taken as fact, it would sort of end up that those areas were a no man's land, you know, outside the individual stores, but still in what appears to be a common area. So we think that's definitely a question of fact. I want to address the negligent training and hiring question. Well, that actually ties right back into the common area question. You know, they say the security guard was not on their payroll, but part of this is the lack of proper security in a broader sense, that they're responsible for the security in this common area. And it's not just whether that one person was on their payroll, but should somebody else have been on their payroll? Should they have rethought about who they're using and how they're approaching security in general? So I want to just real quickly, the mutual combatant issue, I don't think is that determinative. First off, that's a really fact intensive issue about who knew what at the time. And
well, in fairness, I mean, normally I would agree with you that whether there was mutual combat, et cetera, tends to be a fact intensive analysis. But Ms. James has pointed out that your client says that he knew, or at least had a reasonable belief when he injected himself into the disagreement, that perhaps the alleged shooter was armed and was perhaps about to take, you know, shots at somebody. And so if that's the only evidence, right, then why isn't that evidence of your client's at least equal, if not superior knowledge of the specific hazard that the shooter posed?
Oh, I'm glad Your Honor raised that. I believe, and I don't have his depth in front of me, but I believe he's saying that though, like mid-struggle or mid-confrontation. And rather than saying that like before he even enters this situation. So he witnesses, you know, this threatening situation happening near him, and that's the pivotal moment. I don't think gaining knowledge halfway through a confrontation is the same as if he didn't feel that he needed to intervene, and that's where the that's where the negligent security and training and hiring goes in, is that the whole situation, it has erupted to the point where, as a citizen, he feels he needs to step in, and he did not have knowledge equal or better than Greenbrier had at that pivotal moment. I think he says that like later on, you know, as and by later on, I mean moments later, but it's significant that as the confrontation is heating up, he says, and he's at that point, it's that pivotal moment is past. Also, I think, as a second point, it's sort of a question of fact about, you know, what did you think would happen, asked in a deposition, you know, later, is not, you know, doesn't completely foreclose that Greenbrier could have had knowledge of that they needed more security. You know, when he says in the deposition, basically at some point he became aware that if he wasn't stepping in, that something, you know, bad could happen to this woman. I think that would definitely be a question of fact as to whether Greenbrier could have years worth of knowledge of a growing security concern in this area.
Okay. Question, who, to your way of thinking, the security officer that was present, who did that person belong to, that they're referenced as the contracted security officer?
You know, I don't, you mean like who's the employer basically, or
Yes.
Direct or indirect? I don't know. Offhand, if it's something it's probably something I've read, Your Honor, and it's not coming to me right at this moment.
Okay.
And I mean, and I think I said this, so I won't dwell on it, but I think our claim in part is that the security was insufficient, you know, that one. So it's not just who did that person work for, but who else should have been there, or how should things have been controlled?
No, I understand that, but to the extent, the reason I'm asking is that to the extent that a security officer was present, your argument, at least in part, is that the Greenbrier Marketplace was not an out of possession or out of control landowner because it retained contractually the right to, or obligation to, depending on how you characterize it, provide policing. And then the facts indicate that there was a security officer present. And so my question is, who was providing that security? Who's responsible? Who ensured that that security officer was present? That's what I'm trying to get to the bottom of.
And Your Honor, it's a great question. I just don't have the answer as we think.
Fair enough. Keep going. I didn't mean to interrupt.
No, I think I actually got through the points, unless Your Honor wanted me to address anything else. So I happen to be at the end of my list right then.
Okay, no, that's fine. If you could, so I understand that the alleged underlying security or lack thereof, et cetera, is the basis of the claim. But factually, but it's been raised in the complaint as both a premises liability claim, which we spent a good deal of time talking about, but also as a nuisance claim. And I didn't hear you respond to their argument that there's not really a nuisance claim here, even if there might be a premises liability claim. And then also this negligent hiring aspect, right? So as Ms. James points out, I don't think there was a great deal of time spent trying to, my experience as an attorney tells me that you allege all the things and then you develop the claim. And perhaps we're at the point where the plaintiff may be in a position to say, we're not pursuing the negligent hiring. I don't know. But certainly I want to give you an opportunity to respond to that, because the defendants have asserted that there's just no evidence in the record indicating anything associated with some sort of negligent hiring, supervision, retention, et cetera. So I wanted to give you an opportunity to specifically address, as I read the complaint, what I think are counts 2 and 3 that I wanted to give you a chance to respond to, because their motion does seek summary judgment on those 2 claims as well.
Thank you. Yeah, as to the nuisance claim, we can be quick about that. It's not other than a premises claim. And so, yeah, pled broadly in the beginning, our nuisance claim is not different from the premises claim. And so therefore, I think we'd be at a point where we'd be either dismissing it or at least not opposing it in the summary judgment.
Okay.
The negligent hiring, it's negligent supervision or training in the sense that there should have been more security there.
Okay.
So even if the security guard isn't in the chain of command, and Your Honor's raised a very good question about that, we think that there's still an argument that's beyond premises liability about how security and policing is being done, because after all, in the lease, it says that's going to be a charge paid by the tenant to police the facilities and common areas. And so it's in setting that up, supervising that, establishing that, overseeing it, that even if the answer is, well, nobody was doing it, nobody was there, we still think that could be a negligent supervision issue.
Okay. Thank you, Mr. O'Brien. Ms. James, I'm going to give you an opportunity to respond, but I'd ask if you could answer my question first. What do the facts say regarding who was responsible for that security officer's presence?
Okay, so the facts, as I know, the facts say that it wasn't Albert Escudi nor Greenbrier Marketplace. I can tell Your Honor from the prior case that from my understanding, that was the entity who leased the premises, 2925 Properties LLC. They're the ones who were listed as the tenant, and they're the ones who would have secured, from the best that I can recall, have secured his presence.
Okay. So your position would be that there's no evidence in the record that indicates that the security officer who was present was retained was being provided or contracted by either defendant Greenbrier Marketplace or Albert Escudi. Is that correct?
Yes, Your Honor.
Okay.
And I think, plaintiff is here making arguments today, but in response to a summary judgment, they're supposed to be pointing to actual evidence. And so I don't want to sort of just go down the different arguments that are being made, as opposed to pointing out that at this time, he's supposed to be pointing Your Honor and myself to the evidence that would dispute what we put forth in the affidavit of Albert Escudi. And that has not been done. So yes, there is nothing that has been provided to suggest that the security officer was in any way hired, retained, trained by the defendants in this case. And the only evidence is what has been provided in the affidavit, which explicitly states the opposite, that neither Albert Escudi nor Greenbrier Marketplace hired or provided security services for the premises. In that same vein, plaintiffs are arguing that the fact that there was not security is something that is a question of fact. Those are arguments, and again, there's no evidence that plaintiff has pointed to suggest that had there been more security, if we were responsible for the area, that this would have prevented or decrease the likelihood of something like this happening. It's not enough just at this stage to sit here and say, well, this is what I'm going to argue to the jury. He has to satisfy, Your Honor, that there is actually evidence as to these arguments to sit here and get to go in front of a jury. And that's not being done. All that's being made in plaintiff's response brief is just sort of, well, we can say this, without actually pointing to, Your Honor, what the actual evidence is in support of these claims. And this is the stage to do so, at the summary judgment stage. And with respect to the mutual combatant argument, I would have to disagree with Mr. O'Brien. I think it was pretty clear in the testimony on page 94 that that was before the physical confrontation had started, when Mr. King talked about, I've seen a weapon, feeling like he was going to use a weapon. And then specifically, I would ask Your Honor to look at pages 265 and 266 of the deposition, where plaintiff also admitted that, you know, during the course later on of the confrontation, that he had an opportunity to back away and leave before the shooting took place. That part was talking about in the midst of it, and that he could have left at that point. But prior to the plaintiff being actually the first one to sit and make a move physically towards Nico Bell, the eventual shooter, that he intervened because he thought that by Nico Bell putting his hand in his pocket and saying, this ain't what you want, that he was referencing using a weapon, and that he may, you know, he says, is he about to shoot her? I don't see how that knowledge cannot be more superior to any of the defendants, assuming again that they even had a duty under the premises liability theory. He was the one who was there that day. He is the one who saw, prior to the shooting taking place, Nico Bell engaging in aggressive behavior. He is the one who thought to himself, is he about to shoot this woman? And he then decides to go and de-escalate the situation. How is his knowledge not superior to that of Albert Ascudi of Greenbrier Marketplace 2 LLC, who had no control or possession of that area on the date in question? So perhaps it would be a question of fact if there was actually some conflicting testimony as to that issue, but it's not. It's simply the plaintiff's own admissions as to these facts. So I don't see how that can be deemed a question of fact or something for a jury to consider when there is nothing that contradicts the plaintiff's own admissions as to this issue. And then lastly, with respect to, we didn't touch on this too much, but it would go in line with the fact of punitive damages, and there has been nothing that plaintiff has pointed to suggest that punitive damages would be on the table here. It's not enough to just generally say, well, we think they they didn't take crime seriously, and so that goes to a jury. He has to point, Your Honor, to specific evidence that shows that Albert Ascudi and Greenbrier Marketplace 2 did something so severe that they need to be deemed, have their action deterred in the future, or something that shows willful misconduct or wantonness. There is no such evidence that plaintiff has pointed to in response to this. And I would also say that the loss of consortium action.
Hang on, sorry, 1 second. You're breaking up. I don't know why, but you're breaking up on me just a little bit. Just that last sentence you started with, I didn't quite catch it, Miss James.
Okay, sure. Can Your Honor hear me now? Okay.
I can, yes.
With respect to the loss of consortium claim, obviously we feel like this entire case should be judgment entered in favor of the defendants, and as a result, derivative claims such as punitive damages and the loss of consortium claims would go along with that. And we just feel as if at this point, plaintiffs have not, in response to this motion, presented any admissible evidence that would actually cause an issue of fact. They've made arguments here today, but at this stage, they are supposed to actually have evidence to show this is what a jury would be disputing. And I would just ask that Your Honor enter judgment in favor of the defendants Greenbrier Marketplace 2 LLC and Albert Escudi, and grant our joint motion for summary judgment.
Okay. So I do have one set of follow-up questions. I think I understood, and I think probably my question is directed at Mr. O'Brien, but I believe I heard Ms. James indicate that Albert Escudi is a member of an LLC that is a member of Greenbrier Marketplace, the second LLC. Is that accurate, Ms. James?
Yes, Your Honor.
Okay. So with that, the nature of that relationship, one of the things I'm struggling to understand is, I think, given that Mr. Escudi's affidavit is part of what is relied upon by the defendants in terms of the undisputed facts and the out of possession ownership, I guess I'm struggling to understand where is the nature of the direct action against Mr. Escudi, separate and apart from whether these causes of action are properly crafted or alleged, et cetera, for some reason, whether they're facts that need to be resolved. I'm struggling with how Mr. Escudi is an individually named defendant. What is the nature of Mr. Escudi's role that Mr. O'Brien, that plaintiff believes make him someone who is potentially in possession or control of the property?
So as our original pleading was that he was exercising control of how it operated. However, and maybe we should have clarified this. I don't think directly as to Mr. Escudi that we're countering the arguments that are made now by affidavit that his only relationship is an ownership one through two LLCs. I'm not sure it matters that they're two LLCs, but they're in other words, I don't think we're any longer asserting that there's any veil piercing moment.
Well, I mean, yeah, you're correctly understanding what my concern was. He may be protected by 9 layers of corporate entity, but if he was actively involved in the management of the property, that would be a different issue, but that's not what I was hearing. And so that's what I was trying to understand. Okay. So I'm going to start out with the easy. I think that the defendants have satisfied their burden relative to the negligent hiring claim and relative to the nuisance claim, potentially. Now, the negligent hiring, definitely, I'm going to grant summary judgment to Greenbrier Marketplace, to the defendants as to the negligent hiring claim. I am going to consider granting summary judgment on its entirety to Mr. Escudi, because I've not heard any facts that would indicate individual control over the operations or management, even if he is somehow tangentially connected, but I'm going to take that under advisement. The only reason I'm putting a pin in the nuisance claim is that I agree generally with the defendant's characterization that a nuisance claim, even if it's factually based on the same alleged behavior, it is a distinct cause of action that has distinct claims that have to be, facts that have to be asserted to support it. And I'm only taking it under advisement because I'm taking the premises liability claim under advisement as well. I want to look in some more detail at the deposition testimony that I was directed to, particularly the testimony of Mr. King, in terms of what he knew or didn't know, and just generally familiarize myself a little bit more. In particular, Mr. O'Brien's, the briefing that was submitted on behalf of the plaintiff, did in terms of directing the court to record evidence, directed the court specifically to some of those provisions of the lease agreement. And so I want to look a little bit more at that to determine the nature of the cause of action. In terms of what control rights or obligations Greenbrier Marketplace had relative to the premises. Out of curiosity, where is 2925? Were they just not named, or were they named in a previous action that they're no longer a party, or?
They were not named in this renewal. I can tell Your Honor, having been involved in the original, plaintiffs attempted to bring 2925 in a bit into the litigation where the prior judge denied allowing their entry, saying that it was untimely and long after the statute of limitations had run.
I see. Okay. Okay. One other question I did have, is there an amended complaint anywhere? As I read the complaint, the punitive damages action is still pending. The count for punitive damages is still pending, correct, Mr. O'Brien?
Yes, I believe so.
Okay.
Yeah.
And Ms. James, your argument on summary judgment is simply that both of those claims are derivative, and therefore, because your position is that the underlying claims fail, the punitive damages and the consortium claims also fail.
In part, but also substantively as to punitive damages. I just don't see where plaintiff has pointed to evidence that shows conduct on behalf of the defendants that's worthy of punitive damages, which is required. So substantively, and then yes, because it is a derivative claim.
Okay. And then last question about Mr. O'Brien. Your briefing pointed to, and Ms. James briefly referenced, a crime report that is in evidence. It's in the record regarding, crime statistics, occurrences in the surrounding area. Is there any evidence in the record of prior shootings, criminal activity, or incidents on the property or at the mall?
I don't know if it's in the record. I mean, I don't know. Yeah,
Okay.
I'm sorry, I don't know. It's certainly something I could find out.
Okay.
May I
Yes, Ms. James.
it's my position that no, there is none. And then also with that crime report, along with the request for admissions, we served interrogatories and request for production of documents. This is the first, I believe, that we're seeing this in this motion. So to the extent that we think that, that's not something that we had an opportunity to sit and review in this litigation. So we think it's improper for it to be included at this juncture anyway. But even beyond that, no, that's the only thing that they have provided in response to this motion, or in this case, that's the only evidence really, period, other than their response to the RFAs that the court is allowing. So no, that's our position.
Okay. I understand. Yes, sir, Mr. O'Brien.
Just real quickly, there is a big question, and we addressed it a little bit about, is discovery still open or not, based on the 6 months after the last answer date. And so, as to whether some of those things are in evidence already, we'd ask too that Your Honor consider denying the motion, and just without prejudice, if needed, to them refiling it after discovery is finalized.
So here's the thing. So granted, it's very it's a little sloppy, and I apologize for that, but the court did enter a scheduling order on November the 2nd, which is the court's standard practice. And what I do is I send out a notice that says, I'm going to enter a scheduling order if y'all don't. And the reason I do that is I say, if y'all need to take a year to conduct discovery and y'all think that's reasonable in the nature of the case that you have, then tell me that, and I will allow it. That's not what happened here. I sent out a court-issued scheduling order and no one responded to it. And what my notice says is, if you don't respond, then here's the order I'm going to enter, and that's what we did. Now, the part of it that is sloppy, and I do apologize, is that the dates are a little bit all over the place. But I think if you read it in context, clearly the end of discovery was December 22nd of 2023. And the deadline for dispositive motions was January the 22nd of 2024. Now, I can't, I'm not sure why it says that defendant's expert disclosures and rebuttal expert disclosures are sometime in November and December of this year, but I think it's fairly clear from the context, given the fact that the deadline for discovery, dispositive motions, and the trial date are all appropriate and on the target time that we're on. That November 15th of 2024 was intended to be November 15th of 2023, and that the rebuttal disclosure deadline or for rebuttal experts was intended to be December the 1st of 2024. Regardless of that typographical error, it's clear that discovery ended on December the 22nd of 2023, and no one asked the court to extend it. And so that's where we are. So I can't stop you guys from continuing to engage in the discovery process after that time has passed, but my position is that I'm not going to enforce those types of discovery disputes because I entered an order and I expected the parties to either follow it or ask me for more time. And nobody did. So I will also note that that scheduling order included with it a deadline to mediate on March the 22nd, no later than March the 22nd of 2024. Technically, it's not a requirement that you mediate. It's simply a requirement that if you're going to mediate, you do so by then. So I don't know if you guys have mediated or not. I will say that it is my intention to place this on the calendar for trial if I don't grant summary judgment in total. If any part of the case continues to exist after the summary judgment motion, then I do intend to place the case on the next available trial calendar, which theoretically would be the end of April, although because of my criminal trial calendar, it may get pushed a little bit further out than that. But either way, you would receive a notice that your case is set for a pretrial conference, which looking at it may very well be that it would, I will rule, and if any part of the case it continues to exist, then y'all would receive a notice probably for the first week of May for a pretrial conference, and that would be the deadline for your pretrial order. And then you could expect to proceed to trial later in that month. Anything else that y'all need me to address or take up? Oh, I will add one other thing. What I typically do after I've had a chance to look is I will rule. I will often send the parties an email that gives just a brief outline of how I'm going to rule and requests that one party or the other provide me with a proposed order. That's on the summary judgment motion. Mr. O'Brien, I see in the system that the plaintiffs filed a motion to withdraw or a proposed order withdrawing your deemed admissions. If you could please email that to Mr. Freehoff in Word format so that I can edit it as I see fit, I will go ahead and get that on file for you. And then what I will do is sometime in the next few weeks, I will notify the parties what my ruling is going to be. So that if I am denying summary judgment in part or in whole, the parties will know what aspects of the case they need to prepare for trial in time to be able to do so. But what is likely to happen is I will email the parties. You'll get an email from Mr. Freehoff that says the court has decided this is how she's going to rule. Please draft me an order that outlines those general issues, and then I'll ask you to submit it in Word, and I will edit it as I see fit. Anything else that I need to address, Ms. James?
Nothing for me, Your Honor.
Okay, Mr. O'Brien?
Nothing from me, Your Honor.
Okay, thank you both for your time and your presentations, and I will be in touch with my ruling, and I will look for that order on your motion, the proposed order with allowing the withdrawal of those deemed admissions.
Great. Thank you very much.
Thank you all. Have a good day.
Thank you. Thank you.
Mr. Snyder and Mr. Coleman. I'm sorry that you drew the short straw and had to wait the longest, but I appreciate your patience. Mr. Coleman, you with me?
I'm here, Your Honor.
Okay. Mr. Coleman, there's there it is. I think your TV must be on. Thank you. Okay. So, where we left this matter, this is Lawrence Davis Jr. As the revenue chief for the city of Atlanta versus a property known as 1111 Oak Knoll Terrace Southeast. I think where we left it procedurally is that the city had filed this action, and that Mr. Coleman is the only person who filed an answer disputing the nature of the relief that the city is asking for. And so, which is a judicial foreclosure, as I understand. And so whatever order I enter will likely say something to the effect of all the other parties are hopelessly in default and failed to appear at the noticed hearing, and therefore have lost their right to challenge or dispute the city's requested relief. However, I am prepared to hear from Mr. Coleman. And so what I'd like to do, Mr. Davis, since the city is the one seeking the relief here, is to call upon you, if possible, to sort of outline for the court the procedural background and the nature of why we are at the judicial foreclosure stage, and why, particularly anticipating Mr. Coleman's concerns about notice, what efforts the city took to properly perfect its procedural requirements to proceed with this action. If you'll go ahead, and then I'll hear from Mr. Coleman to respond.
Sure, Your Honor. And I have an entire NREM administrative file with all of the various documents. I don't know if you want to see that now, but what I'll do is just
not right now.
Okay. So, of course, Your Honor, we know the process of administrative NREM demolition hearings is a public process, as well as, of course, this judicial NREM process. So starting with the administrative NREM process, it is allowed under the Municipal Code of Atlanta, Appendix E, Article 3. That process involves an administrative hearing where a complaint is either made by a public official or 3 residents about an issue with the property. This particular piece of property had suffered a fire, and it was essentially just a shell. And so the code enforcement officers who cited the property cited it for a number of problems, and of course, citing it for health and safety related issues. The next step in the process is that there be notices sent out about the hearing, and there were notices sent from the city's code enforcement office to what was at the time 111 Oak Knoll LLC, which I believe is the entity, the LLC that owns the property. Mr. Coleman apparently is the registered agent, and I believe is the sole member of that entity. So LLC was served, and the property address was served, which are all statutory requirements. The hearing was held. Oh, and a notice of list pendants was also recorded, Your Honor, as part of the statutory requirements. A hearing was held. There's a list of attendees that the city takes for all of its hearing. There were a number of properties that were at this administrative NREM hearing. Mr. Coleman was one of the attendees at the hearing. I believe that was in November of 2020. And then at the conclusion of the hearing, the panel, the NREM panel that hears all these administrative NREM procedures, decided that his property was one of the properties that should be demolished as a health and safety issue. I assume Mr. Coleman spoke at the hearing, but I have no idea, and he can talk about that. But in any case, he was notified of it and he appeared. Subsequent to that, the city goes about the process of hiring a third party to do the demolition of the actual structure on the property. In addition to that, they have an asbestos survey and a number of other things that are done, all which of course cost money. And they record all of those things. They take pictures of them. They have invoices that reflect the cost that they incurred, and all those things I have for you. Again, all these are public procedures, so all the documents are publicly available, Your Honor. When all that was done, the demolition was done, asbestos clearing was done, the city incurred a total principal balance of $22,457.22 to demolish the structure. That amount became a lien against the property, a demolition lien. The lien incurs a 1% interest each month until it's paid. And so as of the date of the filing of our petition, the amount was at $25,905.75.
So, Mr. Snyder, let me ask you a question that I frequently ask the city in these contexts. Why is it so expensive to demolish what is, I would assume, a fairly small and already significantly damaged property?
Well, Your Honor, I will tell you that it's a third party that does the demolition. So
Right.
there's a contractor who comes in with bulldozer and all the other things. I would tell you, and just from me being in this business, if you will, of dealing with contractors and things like that, it is the equipment rental, it is the labor that is associated with it, and it is the actual remediation of the property. And if I show you a photo of it, you'll see now that it is literally a flat, empty lot. There's nothing there. So
Okay.
it's not simply the tearing down of the structure. Of course, you have a foundation, all the walls and everything else that go into construction of a typical home, but then removing all that material and taking it away, and some of it, oftentimes in these older homes, they contain asbestos and asbestos remediation and everything else that are part of that process. So it's not simply just like running in, knocking it down and leaving. You have to actually take it all away and make sure everything is done safely, and that when you leave it, there's nothing left there. So I think that's part of the reason that it runs up into the $20,000, $30,000 range, which is pretty standard, pretty typical.
Okay. Thank you, Mr. Snyder. Okay. What I'm going to do, Mr. Snyder, is call upon Mr. Coleman and hear from him now, and then I will let you have a brief rebuttal if you wish to have one, okay?
Yes, Your Honor. Thank you.
Okay. Mr. Coleman, I'm going to let you respond in whatever manner you would like to. I would be interested in hearing one thing that you mentioned earlier. I would be specifically interested in hearing about the costs and expenses that I think you said you incurred associated with the property, and how that relates to what the city says it did. If you could go ahead and address that for me. And I know also you wanted to raise issues of whether or not you received proper notice. So, and you can tell me anything else you want, but I did make a note that you wanted to address those specific issues. And so I wanted to remind you to address them for me.
Well, thank you, Your Honor. Since I've acquired the property, the area was not that well. It was pretty dilapidated, and there was a lot of dumping that took place on the property. We're receiving notices from the city code enforcement, which I will go take care of. If it was nothing more than tires, I'd remove the tires. If it was mattresses, I have the mattresses. I would remove the mattresses and cut the grass, and basically get the property up to what the standard in which code enforcement, needed it to be. I did go to a court case in reference to the property being demolished prior to it being demolished. And at that time, I was told if I board the property up properly, because it was deemed to be a hazard because it wasn't boarded up properly, and they said that people could get in and out of the home. So I said, not a problem, I understand. We cut the grass, and we boarded the home up. Court enforcement came back out. They took a look at the property. They said everything was good to go. I assumed at that time we were good to go. The only other notice that I received stating that there was a problem with the property was in the future. I received another notice of non-compliance. And I went out. At that time, I noticed there was a silk fence around the home. So why is there a silk fence around the home? I was told that code enforcement came out. They told me at the time there was a notice for demolition on the property. I said, well, why how is it possible a notice of demolition on the property and you all are continuously sending me notices and I'm coming out here cleaning up the property? Like, when did we skip this step? How did we get to this point? Because if you're going to tear the house down, why am I paying and coming out here to clean the stuff up? I was told at that time, like I said, there was already a judgment that had taken place that I had no knowledge of whatsoever. I did make contact with the city at that time. I actually also went down to the mayor's office. Upon going down there to the city and speaking with the assistant in the mayor's office, I was told that at this point, and at this junction, we actually called over to the office in code enforcement that does the demolitions, and they said that attempts had been made to send out notifications and to reach me and contact me. And I said, well, I don't understand, because it's been the same exact address. Had a notice been sent to me, I would have gotten it, just like I get the property taxes and the notices from code enforcement.
2 questions. Forgive me for interrupting you. When you say the address has been the same, what address? Are you referring to the property address where you're receiving that, or is it a different registered address associated with you? You don't have to tell me the address. I'm just trying to figure out if it's your address or if it's the property address.
The address in which all mail comes to in regards to the property, period, point
Okay,
blank.
so it's your address, not the residence, not the property address. Okay.
Correct.
Okay. And then my second question is, I think I understand Mr. Snyder to be saying that one of the notices that would have been sent out was a notice for a hearing, a demolition hearing, and that the records of that meeting indicate that you were present. Can you address that for me in terms of whether you were present and what your understanding was of what was happening at that meeting?
The hearing that I was present to basically stated that, from what I can remember, that the property needed to be brought up to code. Or if it was not brought up to code in a certain amount of time, that that it would be another hearing to have the property to vote on it again to see if the property is going to be demolished.
Okay.
And they gave me a certain amount of time in order to do it. I got the house up to code in a certain amount of time. I actually spoke with code enforcement. They came out, a female, she walked around the property with me. She said everything was good to go. At that point, I figured everything was solved. The next thing I knew of was basically, like I said, when I was out of the property, there was a silk fence around the property. And code enforcement tells me that there has been a order to demolish the property. So, I mean, at this point, I started receiving the invoices at that time after that, saying that, okay, yep, we got, because when I called down, I spoke and went to the mayor's office, and I actually spoke with the assistant, and we called down to code enforcement. They basically told me that's when they said, okay, well, we have sent out notices, but we sent it to the actual property itself. And I said, why would you send anything to the property when everything comes to my house, which is the only address that I've ever used in regards to that property? The code enforcement notices come to that property, the property taxes come to the property, the city sanitation, everything comes to one address. So where the confusion came in with that notice is the problem that I'm having. But at that time, they told me, all right, there's nothing we can do, Mr. Coleman. Once the process has begun, there's nothing that we can't go in and undo what's already been done. So I said, okay, well, if there's nothing I can do, what is my next step? They said that you're gonna have to make the payment for $22,000. I didn't have the $22,000 at the time. All right, just did not have the funds in order to satisfy that amount. I did receive a letter in January, February, March, April, May, June, July, August, September. I received a letter back in September stating that.
I'm sorry, Mr. Coleman, of 2023?
Correct.
Okay.
And it said that basically I have to, I need to satisfy this debt. And there was a order asking for the demolition, I guess, and the foreclosure of my property. So at that time, I made a payment of $25,905.75 to satisfy the lien. All property taxes have already been paid. So at this point, I'm trying to
wait, Mr. Coleman, let me back up.
Yes.
You're saying that because that was one of the things that piqued my interest at the beginning of this process when you said I paid almost $26,000. Tell me the exact amount of that of money that you paid and what information you have regarding when that was paid and to whom it was paid.
It was paid November 2nd. It says received Department of Finance, November 2nd, 2023. And it was for the exact amount, hold on, the exact amount of $25,905.75.
And your belief was that you were making that payment to satisfy the demolition lien that had been asserted on the property. Is that correct?
Unjustly asserted, but yes, Your Honor, that's what I believed.
I understand. Okay. Mr. Snyder, do you have any record of that payment?
I have no record of it, Your Honor, but in light of that, I certainly would like the opportunity to go confirm if our finance department received the payment from him. They didn't notify me, and they probably wouldn't. It's sort of a disconnected process, because once we started it, we were just waiting for a hearing and to actually get a payment to us.
I understand.
Since he went to the finance department, I would like to confirm if he did.
Right,
If he
so-
did, I don't think that we have any further.
Right. So here's what I think we should do to try and resolve the issue once and for all. I have another hearing on this on this Zoom link today at 1 o'clock. What I would like to do is, hopefully, I know sometimes it's not as easy as just making a phone call when it's government, because there's lots of different departments and all that good stuff. But if there is any way that you could confirm that by later today, by say 3 p.m. And let me know, and then you could announce to the court, for Mr. Coleman's benefit, that the city will be filing a dismissal of the current judicial foreclosure action. Or if you're not able to resolve that issue, then you can let the court know if you're not able to get the information that you need to be able to announce a dismissal, or to announce that we have no record of that payment or whatever, right? Then what I can do, if it's okay with both parties, is simply require that the city no later than, what is today, is the 4th. So we can do it by the 11th, which is a week from now, to have the city either notify the court that it has confirmed payment and is dismissing, or notify the court and Mr. Coleman that it is not able to confirm that payment and wishes to proceed with the case. We can sort of do it, but what I don't want to do is leave it wide open, so that Mr. Coleman is sort of still sitting out there waiting to find out if this cause of action is still there or not. Do you think does that sound reasonable to you, Mr. Coleman?
That's reasonable, Your Honor.
Okay, Mr. Snyder, is that doable?
Yes, Your Honor. I'll make every effort to find out today if
Okay.
possible.
Well, and so here's what I'll do. Like I said, I'm going to be on this Zoom link. So if you're able to confirm it at 3 o'clock, then just jump on the Zoom link and let me know.
Okay.
If you're not able to, I understand that. Email the court, copy Mr. Coleman, and let us know that you're still trying to confirm that. But basically what I'm looking for is, if you are able to confirm that the payment was made, what I'd be looking for is a dismissal by the city no later than the 11th of April, which is next week.
Got it. That's no problem, Your Honor. I'll do that. I would ask one thing before we jump off, if
Yes,
it's
sir.
okay with the court. I just want to confirm Mr. Coleman's email address.
Yes, Mr. Coleman, Mr. Snyder's going to confirm that.
I'm ready when you are.
I have, it's chrisc235@gmail.com. Once again, Chris, the letter C235@gmail.com.
Okay. So, Mr. Coleman, I will email you along with Judge Krause's staff attorney to let you know kind of where I am, just to make sure.
Excellent. Well, I'm sorry that I took so much of your time today, but it feels like we've made a little bit of progress, and maybe we can figure out what's going on from here. And so I will look forward to either hearing from you at 3 o'clock or to a dismissal or some other action no later than April the 11th. Okay.
Very well, Your Honor. Thank you very much.
Thank you both. Have a good day.
All right, you too.
Thank you. Okay.
Good afternoon, gentlemen. If you will give me about 2 minutes, I will be back with you and we will go ahead and get started. Thank you.
Thank you, Your Honor.
Okay. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Hi, so I have on my calendar for today, the Eric and Sean Stroud versus Daryl Stroud matter. Who do I have here on behalf of Eric and Sean Stroud?
Good afternoon, Your Honor. Roberto Bazzani of Druggel and Farnham on behalf of the petitioners. And with me is Mr. Jason Crosby, who is the appraiser that performed the original appraisal for the property.
Okay. And who do I have here on behalf of Daryl Stroud?
Steven Schreiber. I'm the and Daryl Stroud is here as well.
I see Mr. Stroud. Thank you. Okay.
And good afternoon, Your Honor. I'm Kyle Williams. I'm the court-appointed special master in this matter. I think I'm the least important person here, but I wanted to at least be available because I received the court's notice and I just wanted to zoom in, but I'm here as well.
Well, I appreciate your presence and I appreciate the work that you have done prior to today's hearing. So I'm going to start by saying, here's what I think I know about y'all's case, right? And then I will invite anyone to correct me. A couple of things I do want to be clear on. I have a fairly tight schedule. I know there was a very large request for time. But the reason that I have limited it, to be clear, is that my understanding is that I was being requested to hold a hearing that lasted longer than the hearing in the underlying special master proceeding. And that seemed to not be a valuable or efficient use of the court's time. Because I do have the benefit of the special master's reporting, albeit that is the subject of challenge by Mr. Stroud, Daryl Stroud. And I apologize. I normally call everybody Mr. or Ms., but obviously for the purposes of today's hearing, I'm going to have to refer to Eric, Sean, and Daryl, which really bothers me. And right now my mom is somewhere really mad, but I'll do it so that we can keep it straight. What I think I understand is that the parties are, this was I think a partition action where the parties own, I think, equal undivided interests in the property that they are seeking to partition, and that once the partition was made, I think I understand there's obviously a fundamental dispute about the value of the property, but also about I think what goes to the dispute about the value of the property, as I understand it, is this repairs that may or may not need to be made to the property that will be expensive repairs to make it marketable, et cetera. I think that's what I understand Mr. Scriber's client's position to be. One thing I did want to make sure I was clear on in terms of the procedural posture of the case is that once the special master had made a finding, if it were to be to move forward in terms of a finding of value, the idea was that there would be an opportunity for Mr. Daryl Stroud to, if he wished to exercise an option to purchase the full property based on the value that had been estimated or that had been assigned by the special master if the court were to accept that value. And that's part of where it broke down, because Daryl Stroud believes that the value is too high, therefore requiring too much capital for him to be able to purchase the property. That's what I think I understand about the case. Mr. Scriber, did you have a concern? I mean, obviously, I'm going to more substantively, but
your understanding is generally correct. But as far as the very last thing you stated, I just wanted to make sure that we do think it's over that the appraiser's report was too high, both based on repairs and the condition. We have had other appraisals, but also if it were listed for sale, it would not net what we believe the original appraisal had stated.
Right. And I do recall there being some discussion in the underlying report that I've seen that that a competitive market analysis might yield a different result than perhaps an appraised value. I'm aware of that. So, okay. So with that, one question I have, because I don't do these very often, is procedurally, is it the party challenging, or is it the party asking the court to accept, or does it matter in terms of who I'm going to hear from first?
I think procedurally, Your Honor, it would be up to the objector. So Mr. Scriber.
Okay, that's kind of what I thought, but
that's what I would think too. Yeah,
okay,
sorry, I didn't cut you off, Your Honor.
No, that's fine. That's kind of what I thought, but I wanted to make sure we were all on the same page. Okay. So, Mr. Scriber, I am going to turn it over to you, and you can go ahead and get started.
Okay, and just as a procedural thing as well, is it okay if I'm going to forego an opening?
Okay.
To move this along.
Okay.
And I will call my first witness, my only witness, primarily as Daryl Stroud. I believe. Okay. If Angel Stroud's there, if Angel Smith is there, I might call her as a second witness.
Okay.
And Your Honor, if I may, just as hopefully to move this along as well, to the extent that Mr. Scriber intends to use any of these reports that he filed about an hour ago as exhibits, I would object to them being admitted to evidence as hearsay, untimely based on the court's order, I believe the court's order was that any exhibits that were intended to be used in this hearing needed to be filed by yesterday. And to the extent that Mr. Scriber does not have anybody else besides Mr. Stroud to testify as to these invoices and appraisals, he did not perform the appraisal. He did not create any of the invoices. He did not create the report from the realtor or the offer to purchase the property. So I think it's inadmissible hearsay.
And okay, I will respond. The order does not. I'm looking at the notice of hearing via Zoom video conference. It does not state when an exhibit has to be submitted via. I might be missing something, but when I clicked the link on the standing order, it actually didn't bring up a website.
Hang on one second. Let me pull up. I was in the process of trying to pull up the docket on this case so that I could have access to it.
Judge, it's your staff attorney here. If you'd like me to read the relevant portion of the notice, I can.
Oh, please. I'm looking at it now. I must have missed that part because
The court will hold a hearing on defendant's motion asking this court to reject or modify the special master's report, docket number 22 in this matter. On today's date, via video conference, the party shall ensure all exhibits have been filed into the record at least 1 day prior to the hearing, and then email courtesy copies to the court at, and it lists my email address. So
okay. And to be clear, most of my exhibits were already submitted in the initial objection. I think the only other thing that was missing is the first exhibit, which was an appraisal report, but the other ones were already on the record.
Okay. To the extent, I think that Mr. Is it Bazzani?
Bazzani, correct,
Okay.
Your Honor.
I wanted to say it right, and I was like, I'm gonna mess it up.
I appreciate it.
To the extent that Mr. Bazzani has raised an objection regarding your reliance on any of these new documents, I don't know if they're new or not. But I will say anything that was presented today, I think we're going to need to take it on a case-by-case basis because it sounds like your position is that those documents are a part of the record because they were either before the special master, considered by the special master, and or they were filed as part of your objection to the special master's decision.
That is correct. The only all but I think literally of the 5 things, 4 of them were previously on the record already.
Okay. So, Mr. Bazzani, as we are discussing any of that information, then you can provide the court, you can object it to the extent that he's referencing anything that wasn't already part of the record.
Understood, Your Honor.
Okay, go ahead, Mr. Scriber.
And Mr. Stroud, could you please unmute yourself?
Hey, can you hear me?
Mr. Stroud, can you raise your right hand, please? I think your attorney has called you as a witness. I'm going to swear you in. Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, thank you, sir. You may lower your hand. Go ahead, Mr. Scriber.
Yes, and may you please state your name for the record?
Daryl Stroud, Sr.
And what is your relationship to the property at issue, the 989 Burnt Hickory Drive?
Well, I'm the son, my mother's son, and she, with the property, all 3 of us were placed on the property on the trust, a living trust.
Okay, are you currently living at the property?
Yes, sir.
And how long have you lived there?
I've lived here since January of 2024.
Okay. And is anyone else living at the property with you?
My son.
And what's your son's name?
Daryl Stroud, Jr.
And how long had he lived in the property?
Well, he's been here all his life.
How old is he?
He's 25.
Okay. And can you, I guess in your own words, kind of describe the condition of the property right now?
Well, right now we're having we had plumbing issues where it was a soft tissue blockage, which caused the sewer to back up all over the house.
Mhm.
So we're having to get it mitigated, and they had to come in and basically take out the bathrooms and the kitchen sink and stuff to dry everything out with mitigation. And in the back bedroom bathroom and the carpet. So there's a lot of stuff that is going on that I've been trying to take care of. And before we had a gas leak, and I had to take care of that. So it's just a lot of ongoing things with this property that I've been trying to patch up and take care of. And I can't get everything done until really we get this situated.
Okay. And I apologize. I'm gonna step back because I saw it as a procedural thing. Is anyone there in the room with you?
Yes, Angel
And what's her last name?
Smith.
I just want to make sure it's okay with the court that Angel Smith is
I'm
there.
here.
I will be calling her as a witness as well.
It's not a Zoom hearing unless somebody tries to talk while they're
No.
muted. If technically no one has invoked the rule, so there's no reason she can't be present. But if somebody wants to invoke the rule, then I would need to ask her to step outside the room. Mr. Bazzani?
We're fine, Your Honor.
Okay. Then I thank you for bringing that to my attention, Mr. Scriber, but I think it's fine for Ms. Smith to remain in the room.
Thank you. I just want to, I appreciate that. I'm sorry, Mr. Stroud, I didn't mean to cut off the flow of questions. How long has let me step further back. What other issues exist with the property?
Whereas it's electrical issues, we have roofing issues, and we have issues with like tree branches falling, so we have to deal with that. And the HVAC, we have HVAC issues.
Is the HVAC does that operate?
Yes, it operates so, but it needs to be redone. It needs to be, the whole HVAC system really needs to be redone.
And have you been the primary person as far as contacting people to make the repairs on the property?
No, Ms. Smith has been the primary person.
Okay. And I'll hold back some of those questions then. To Ms. Smith. Have you consulted with anyone regarding the value of the property?
Yes, I had an appraisal come out, and he reappraised the property yesterday.
Okay. May I ask what that valuation was?
It was valued at 232.
Okay. Have any real estate agents, to your understanding, looked at the property?
Not that I know of.
Okay. Is this a property that you believe someone will be, let me go back. So the original appraisal that was done on September 23rd of last year. And Mr. Stroud, if you'd like me to share my screen, I can show it to you if you prefer. But I'll assume, have you looked at that appraisal report?
Yes, I looked at it so not all.
Okay. So I'm gonna assume for this that you've seen it, but if you want me to share it any time, just let me know.
Okay.
I'm just trying to pull something up real quick. Naturally, my computer slows down at the time I need it. So the appraisal report indicates that the property was valued at $265,000. Do you believe that someone would buy the property for that amount?
Well, in the current condition, no.
Okay. And I know you're not an is it accurate to say you're not an expert in real estate?
No, I'm not.
Can you describe the neighborhood the property is located in?
Well, it's an average neighborhood, middle class, maybe neighborhood.
Are
pretty quiet.
the properties that you generally see, are they in better or worse condition than your house?
Well, some of them are in better. Some of them are in better condition, and then you have some that are not. They're not really in that great condition.
In the ones that are in better condition, are they, to your understanding, or how are they being improved for sale, or is it just people renovating their houses?
It's mostly what I could tell, people renovating their houses.
Wow. Have you updated any of the bedrooms or bathrooms in the house?
No.
The appraisal report referred to things like clogged gutters. Has that been resolved?
No.
It refers to water damage, rotten wood. Has that been resolved?
No. Only thing we had done, they had to come in and mitigate it because it was wet to dry it out.
Has that issue existed for a while?
Well, I wouldn't know because it's like inside the walls. And from what the plumber told me, that it was just like an overtime buildup, and it caused what he called a soft tissue blockage, which made the sewer overflow in the house.
And your mom was the original owner, is that correct?
Yes, sir.
And when did your mom pass?
She passed in 2019, December 2019.
And how long had she lived in that house prior to that?
She had been here probably 40-something, 50 years, and she's been here.
So as far as you know, these issues pre-existed her passing?
Yes.
And also the reports mentions like cracks and settlement in the exterior brick. Is that still there?
Yes, they're still there.
Are there still the water stains in the house, the foyer, living room, bedroom, closet?
Yes.
Is there still uneven flooring?
Yes.
Is there still cracks in the walls, cracks settling in the walls?
Yes, sir.
Are there still plumbing leaks?
No, he fixed the plumbing, so he jetted it out and fixed all that. So it's no more water. The the plumber name was Stephen Duff, and he came in and he fixed the plumbing. Well, he jetted it out and cleared the lines out for me.
Okay, was that what you're referring to before with the tissue?
Right.
Can you elaborate on that? I'm not an expert either in plumbing, but as far as what you understand, what the issue with the plumbing is.
From what he told me, like he said it was a buildup of stuff that was in the lines. He said it's built up over time, and he said, well, after a while, it just stops all the way up, and it causes an overflow in the sewer. So that's basically what came. It's like when we use the wash machine and the toilets, the sewer line, it just overflowed in the whole house.
Is there still water intrusion in the basement?
Yes, it's dried up now, but so it's not any more water. But they came in and set machines up and dried it all up.
Did you pay for that?
Yes.
Okay. Is there still mildew and mold?
But they did what they also did the mildew and mold treatment.
Okay, good. Okay.
Yeah. Right.
And is there still rotted wood in the subfloor and joists?
Yes.
Is the electrical wire still outdated?
Yes, it is.
And I don't know if you elaborate. Is this something that you can easily have fixed?
No, it's nothing easily fixed.
Is there still asbestos tape supporting the HVAC ductwork?
Yes, sir. Yes.
Is there still loose tile in the bathrooms?
Yes.
Is there still black stains around the HVAC registers?
Yes.
Is the basement fireplace operable?
No.
And why is it not operable?
Well, it's not operable because we had a gas leak and we had to shut the gas off from the fireplace so to contain the leak. And then we had to get the pipes fixed for the leak.
Are there still signs of, is there still pest rodent intrusion?
Yes.
Can you elaborate on that?
Well,
Like
it's
what
just,
kind of pests and stuff like that?
squirrels in the attic, and we have some chipmunks also that come in the drainage system for some reason. And it's like we had a water bug problem also. So we was dealing with that too.
And have you personally been in contact with any contractors or anything like that to fix some of these problems?
No.
Okay. And who has been?
Well, Angel does. She has been doing all the contact with different people for me.
Okay. And okay, thank you. And and as far as your relationship with Angel, is she acting as your legal agent, or how is that?
Well, she was my power of attorney and she's my friend.
Okay. And I don't know, are you on your laptop or on your phone?
On the laptop.
Okay. I'll hold off on that then. And let me I'm gonna pull up. Okay. Actually, and as far as the condition of property, is there anything that has changed since September 2023?
Just the water backup when it flooded the home. That was it.
And because of that, what's the condition of the bathrooms of the house right now?
Well, they had to take them out. Well, two
What do
of
you
them had to take well, once the water got up under the wood and the tiles and stuff, they had to come in and take them out in order to mitigate it and to dry the wood up. And then they had to spray the mold and mildew to keep it from keep that from getting mold and mildew.
So what do the bathrooms look like right now?
But they're tore out.
Are you able to?
Yeah, all of them except for one.
Are you in the house right now?
Yes, sir.
Are you able to show us what the bathroom looks like if you're able to move your camera over?
Yes, well, we can. Yeah, I can do that.
All right. I think this is highly irregular.
Yeah, but
hang on.
I believe this is relevant.
Hang on,
to show
Mr.
the
Scriber.
condition.
Mr. Scriber, hang on. Let me hear. I'm going to let Mr. Bazzani finish his thought.
Okay,
if there was photographs that could have been introduced, video that Mr. Stroud is now showing us, video of a bathroom that we don't know whether or not it's the actual subject bathroom, subject property. I have no idea where Mr. Stroud is. That's just my objection, Your Honor.
Okay.
The court can weigh it as it
Mr.
likes.
Scriber.
Fair enough. And I apologize, Your Honor, because he didn't raise an objection, but now I understand. So I can build a foundation. We can show the address, the door, the mailbox, that he's at the property at issue. I know it's a little bit unusual.
Hang on,
in
Mr.
that
Scriber,
sense.
sorry.
Yeah.
I'm willing to give him a little bit of benefit of the doubt, understanding Mr. Bazzani's concerns. But let me start with this. So the appraisal indicated that updates included updated bathrooms. So I'm a little confused about what is the issue associated with that there are no bathrooms. Or
Oh, no.
Mr. Stroud, a moment ago, I heard him say that the bathrooms had not been updated. And then I heard him say that all the bathrooms have been ripped out except one.
That's correct. And
I heard
that's where kind of we're getting to the point that
Okay.
That the appraisals inaccurately stated the conditions of the bathroom, that they had both not been updated, and since that appraisal, they have been ripped up. So that valuation should reflect that.
Okay. Okay. Did the appraisal include photographs of the interior rooms?
It did, Your Honor.
Yes.
Okay. Okay. Go ahead, Mr.
And
Scriber.
so, and I think that itself is a baseline that we can compare what the room looks like with what it looks like at this moment because of the actual issues with the plumbing.
Okay. Go ahead, Mr. Scriber.
And Mr. Stroud, would you be
Your
able to?
objection is noted, but I'm going to overrule it for now.
Understood, Your Honor.
And Mr. Stroud, would you be able to show us the bathroom at least, and we can go that the condition of it.
Mr. Stroud, you're muted.
Mr. Stroud, can you hear us? You're still muted. Oh, what's happening? Oh no. Okay, is this
can you hear me now?
Yes, sir.
I can.
Okay, yeah.
And I see
No,
something happening in another video.
Right, we was trying to get the phone. Yeah, okay, there it is. Okay. Can you see it now?
Okay, I was hoping that you would be with it.
Okay,
I
hold on.
I haven't sworn in Ms. Stroud as a witness.
Okay, I can
or
go
Ms.
with
Smith as a witness.
Who want me to be with?
Okay.
Do they need to see the address?
Well, let me back up. I'm willing to give the benefit of the doubt that this is in fact a bathroom that is located inside the home at 989 Burnt Hickory. And I don't think that Mr. Stroud has to be physically present with Ms. Smith if he can identify it as being an accurate video representation of the current status of the bathroom.
Okay, fair enough. I just wanted to be, yeah, fair enough.
I think you still might have lost Mr. Stroud already.
Oh no. Mr. Stroud, can you hear me?
Yes.
Okay, so I now see on a camera that says Angel Smith. Can you see that? Angel S, can you see that?
Yeah, he's on the laptop and I have the cell phone.
Oh wait, Ms. Smith, I can't have you speak because you're not you're not testifying.
So can you mute Ms. Smith so that we don't get any audio? Thank you.
Okay.
Mr. Stroud.
Yes.
Go ahead, Mr. Scriber.
Is the camera what we're looking at now? Is what bathroom are we looking at?
That's the master bathroom.
And what has happened in this bathroom?
Well, they had to take up the towel in the toilet, and you can see where around the wall where they had to cut that out, and all that had to be dried out.
So what am I looking at? I'm looking at the baseboard, I guess.
Yeah, the baseboards, right there. So they had to cut around the baseboard and take the floor up, and they took the toilet out. And like I said, they had to set up the machines in there to dry everything out. And then they had to spray the mold and mildew.
And when did this happen?
This happened on the 26th.
Of what month?
This month. I mean, last month.
Okay, thank you. And just clarify that by that last month you mean March 2024.
Yes.
Okay. And did they give you any quote for how much it would cost to repair that?
No, we hadn't got a quote on anything yet.
Okay. So as far as and you said there was one other bathroom that's also has had the floor stripped out?
Yes, that's the downstairs bathroom.
And I don't know if Miss Smith would be able to show that as well.
Yeah, she's headed that way now.
Okay. And just to clarify, these were all because of the backup.
Backup, right? Sewer backup, right? And now, well, that's the hallway bathroom. She's just showing where
Okay.
they did do the walls in there, but they didn't have to take out the whole bathroom.
So so clarify what's happened to it.
They just cut the bottom walls out, and that's leading to this bathroom in here. And like I said, they had to dry all that out.
Okay, so there's still a toilet
There's still
in
a floor
there?
and on the toilet in there. It's just around the wall.
Okay. Oh, so the lower part of the wall's been cut out.
Right,
And is the sink still operable?
Yes,
and
the
stuff?
sink's still operable, right?
Okay. So that's a but that condition, when did that also happen in March as far as 2020?
26, right?
And I assume, and just to clarify as well, there's been no quote to repair that as well.
No, sir.
Okay.
Okay, and she's headed to the basement, but this is she's going towards the kitchen now, and they had to take the cabinets out right there and cut around that wall, and the machines are still there. You can see where they had to dry it out. Those machines they had to set up and dry it out. And
okay. Is this the same day?
You can see the water damage.
Was it? Oh, just to clarify again, is it the same day that the bathrooms got?
Yes, they did all this in the same day. Right.
Because of the same issue.
Right. Because the whole thing was flooded. Everything was flooded out.
Okay. And as far as have they given you any quotes or any timeline as far as getting this repaired?
No, sir.
How many bathrooms are in the house overall?
It's 3 bathrooms overall.
Okay, so is that other one, but I don't need to see, is that other one operable still?
No, it's downstairs.
Has that been ripped up as well?
Yeah. Yeah, so
And
I'm waiting on her to head down there. She's
okay. And
just showing the hole where they had to cut the holes through the laundry room.
okay, and I will give her a moment. I didn't mean to
She's going down.
make her
Right.
So, Mr. Scriber, while she's traveling, can I ask a couple of questions? I think I heard Mr. Stroud say that this happened March the 27th.
26th.
March 26th, Your Honor.
Okay, so the removed sheetrock and the removed flooring, the removed cabinets that you're pointing to, these are all the result of an incident that occurred on March the 26th.
It was an ongoing issue that I think came to the backup of the sewer, was an ongoing issue, but it resulted in the flooding on March 26th is what.
Okay, no, I understand how you might characterize it. That's not my question was merely that the special master's recommendation necessarily could not have taken any of this into account,
Correct.
The appraiser, because those opinions were all provided prior to this damage occurring. Is that correct?
That is correct. And Angel and Ms. Smith's going to testify about the other stuff that could have been.
I just wanted to make sure I understood the timing.
Yeah.
So go ahead, Mr. Scriber.
No, she's down in the basement bathroom now, just showing you the bathroom where they had to take that out because that's right up under the masters. And that's where most of the water flooded down to. And over in the corner where the bar is, a lot of that flooded out. So it's just a lot of stuff had to be taken out. Then they had to dry all the wood and everything out and spray the mildew and stuff over it to keep it from building up.
And you paid for that as well, that repair? Or we're to get to where we're at now rather than have it remediated?
Yes, they have mediated, right.
And we're looking at that same room as far as
same bathroom, right?
Can you describe, so all the wall have, what's
Yeah.
happened in this room in
That's just the way
particular?
they had to take out the walls. It was mostly paneling right there. So they just took it out. And you can see up in the ceiling where they got the water damage where it came down and like I said, they had to dry everything out.
And what was in that bathroom? Was there a sink?
There was a sink and a toilet.
Okay, was there a bathtub or shower?
No bathtub or shower.
Okay. So it would be fair to call it like a half bathroom?
Yes.
Okay. So, but that stuff, where is that stuff now?
She's just showing where they ripped, where they took the doors and all that.
Oh no, but as far as like where the where the sink and the toilet and the sink are located, or do those have to be discarded, or are those somewhere else to be?
No, they're right there in the garage, right sitting out there where she's showing. They just got everything sitting out there right now. They hadn't picked anything up yet.
Is that stuff going to be reusable, as far as you know?
I don't know. The sinks might, but I don't know until they get into telling me what's going on with everything, how they're gonna do everything. But I know the other stuff is not reusable.
Okay. And as far as any other issues with the property that we haven't addressed either through the original appraisal, I'm going to withdraw my question. I'm going to ask a cleaner question. Since the September appraisal, have any other issues occurred besides the plumbing?
No, only other issue we have here is dealing with the roof and the electrical and the HVAC, but that was already stated in the original.
Okay. And is there anything else that you would want to be on the record as far as what you believe the value of the property is, or what you believe would be a fair valuation for it?
Well, I'm not, like I say, I know, I just felt like it would be lower than what the original appraisal was, but especially since all this is going on. And I just felt that it'll be a little lower than what it was.
Okay. Thank you. No further questions to Mr. Stroud.
Okay, Mr. Bazzani, do you have any questions for Mr. Stroud?
Yes, Your Honor. Mr. Stroud, my name is Roberto Bazzani. I'm with Druggel and Farnham. I represent the petitioners in this case, which are your brothers, Eric and Sean. Are you an appraiser, Mr. Stroud?
No, sir.
Do you hold any real estate related licenses?
No, sir.
Have you purchased a house in the last 5 years?
No, sir.
To the best of your knowledge, did your attorney contact us about any of the flooding issues that occurred last month?
To my knowledge, no.
Okay. No further questions, Your Honor.
I have a question. Mr. Stroud, is there a mortgage on the property?
No, ma'am.
Has anyone attempted to get a mortgage on the property at any time in, say, the last 5 years?
No, ma'am.
Okay. Thank you.
Yeah, you will.
And now, Mr. Scriber, Mr. Bazzani, if you have any follow-up questions to mine, you're welcome to, Mr. Scriber.
I have no follow-up questions on
Okay,
Mr.
Mr.
Stroud.
Bazzani.
None, Your Honor.
Okay. Mr. Stroud, you may be excused as a witness. You're obviously welcome to continue to observe the proceedings. Mr. Scriber, who do you wish to call next?
I'll be calling Angel Smith.
Okay.
And Mr. Stroud, could you mute yourself, because I know you're in the same room, so I don't want like a feedback.
Okay, well, I have to go get her because she was down there with the phone, so I'm gonna go get her.
Oh,
And
she can come
hear.
back up. Yeah, I'll give her a moment.
Right. I go get her
Okay.
right quick. Hey, they need you now.
Okay.
Oh.
Ms. Smith, will you please raise your right hand? Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, thank you, ma'am. You may lower your hand. Go ahead, Mr. Scriber.
And is it just to make sure before I get, is anyone else besides Daryl in the
No.
room with you or anything like that? Okay. And so Ms. Smith, can you describe your relationship to the property? And I know it's a little bit complicated.
I'm Daryl's power of attorney, so I just manage his business. And I've
How-
known his mother since 1994.
How often have you gone to the property?
I'm here taking care of various different things. I'm here like every other month or every couple of months. I come down, check on the property. Daryl Jr. is here, so anything goes on, he'll let me know and I'll come down, or I'll just come and make sure everything is okay. Or if I have to take care of anything personal for Daryl, I'll come down.
And who lives at the property now?
Daryl Sr. and Daryl Jr.
And how long has Gerald, in particular, how long has Gerald Jr. lived at the property?
He's been here all his life.
How old is he?
He's 25.
And you mentioned that you had seen how that you let me back up. What was the condition of the property like when Miss Stroud, the original owner, passed?
The property was it was really bad. He had a lot of electrical issues, plumbing, HVAC, gas leaks. I found the gas leak. It was just a lot of issues.
And have you what's your involvement with trying to rectify them?
As I find it, I call around, try to see who can take care of the situation and just get it done. A lot of work couldn't be done because of the situation with them all being heirs, but any minor things that can be done, I made sure to take care of it to try to so it wouldn't go any further.
So I'm gonna refer to things that are in the report. So are you familiar with the September 2023 appraisal?
Yes, I met Mr. Crosby. He was a nice man.
And I assume I assume you let him in the house to do the appraisal as far as
Yes.
unlocking stuff like that.
Yes.
As far as the condition of the house at that point, how would you describe it as opposed to 2019?
Deteriorating.
Has any of it improved since then?
No, we've done some small work to the HVAC to try to hold it together, but no, everything's been piecemeal.
So as far as I'm going to start with the HVAC. What's the HVAC conditions like? Is it usable?
It's usable, but it's too small for the house. So it'll cause humidity issues. It calls for one half of the house is more heated or cool than the other. It's leaks because of the cracks in the ductwork and because you have some that's fallen away from because of the house shifting. So that's some of it's fallen away. You have where it leaks through the wrap, the asbestos wrapping. Some of it is not even wrapped. So you have leakage from there too.
And these are just observations.
And it's been breaking down because it's
sorry.
a furnace, heat pump type system. So you have the outdoor unit, which is that brings in, and so different things happen, different components of the unit.
Oh, sorry, but these are just your observations as far as like its usability and stuff like that.
Something breaks down, have to get it fixed. So that's what's been going on. Been having various different breakdowns over different periods.
And as far as the electrical system, does that work well?
If the lights flicker, you have 2-prong outlets, it's outdated. You hit the wall in certain areas for the lights to come on. I had the volume muted when I was in the basement, but you had to hit the wall for the light to come on. It's just various different issues throughout. Some outlets are blown, some walls are blown. It's spliced and diced all around the house.
Do you feel safe with the electrical system?
Certain things are taped off so you don't use it.
What do you mean taped off?
Like it's an area in the basement. It's a light that's the light switch is turned off because you don't know what it actually controls. And then when you look up, it's looks like an outlet that's not in the box. So we think it's attached to that, so that's not used, so you don't see what the end effect is.
Have you consulted with any electricians?
Yes,
Have you gotten any quotes for what it would cost to repair that?
yes.
And this is, and I was referring to, do you have like a ballpark of what you've been quoted to get these issues resolved?
It's been submitted to the courts. I can't remember exactly what that was. It's
That's
been
fine. If you don't
quite a
remember,
few
we'll,
months.
yeah. Was that in the, but that was in the prior hearing as far
Yes.
as what, yeah. And as far as, the plumbing issues that were previously identified, have you been in contact with any contractors to get those resolved?
Yes, those have been previously submitted.
Have you received any quotes to resolve those issues?
Yes, those, but what's going on now?
Yeah, I'm referring to, yeah. I'll cleave those apart. So what existing issues are happening now or be prior to?
Prior to there were leaks, drips, they said that it's spliced and diced, like you have the old cast iron spliced in with new plumbing, all over the house, the intake and outlet, well, the drains, you have the intake.
Your Honor, I'll object to her testimony to the extent that she's saying that it's somebody else that's told her this that is not available for cross-examination.
Well,
I'll withdraw to
Ma'am,
that, yeah.
ma'am, sorry.
To that
But
extent.
just for your benefit, ma'am, when there's an objection to a question, you have to let me deal with the objection and then we'll instruct you whether you should or shouldn't answer the question.
Okay.
Okay, and Mr. Scriber, I think you actually indicated that you were going to withdraw the question and rephrase if you choose. Go ahead.
Yeah, and I was going to, yeah, and I understand. I'll withdraw based on your, and Ms. Smith, this is more based on what you observed personally or a quote that you have in your hand, as opposed to what someone else has told you or some information that that a third party would be better situated to relay to the court.
And I'll continue my objection as to her referring to some quote that she has in her hand, as Mr. Scriber has described it.
We can present. Sorry.
Hang on. Listen.
Sorry.
Okay. This is a hearing. It's not a trial. There's no jury here. That's number one. Number two, if you want to ask Ms. Smith if she has an understanding of what the value or what the cost is, as long as she is not reading to me directly from a document that's not in evidence, she can testify about what her understanding is. I just don't want her to tell me X person told me this or to read to me from a report that is not in evidence. Mr. Bazzani, I'm sure that's not what you would prefer that I do, but that's how we're going to split that particular baby.
Sounds great, Your Honor.
Go ahead, Mr. Scriber.
Understood. And for the efficiency, I will ask about understandings, because everything else is on the record, as far as, but what, Ms. Smith, what is your understanding of, what it would take to repair that plumbing part?
My understanding what it would take to repair is to remove and replace.
Do you have an understanding of any dollar amounts? And if not,
Is in the thousands, tens of thousands.
okay, fair enough. And have you, now, I'm trying to, I might have to go ahead and bring in exhibits. What is your, I want to start with this. So, what is the neighborhood like that this house is located in?
The neighborhood is an older neighborhood. A lot of original property owners have passed. You see a lot of investors buying properties and rehabbing and reselling. That's what's really going on in the neighborhood right now.
So are the properties that are being sold in the neighborhood, what's your understanding? Are they typically the properties in their older condition, or are they properties that have been renovated?
It's a mix right now. You do still have a lot of older properties that people have taken care of, but right now it's a lot of investors that are buying properties and flipping them.
And those property, presumably is your belief that they're fixing them up before selling them?
Yes, because the majority of them are repainted and the landscape is different. New windows and
Mhm.
various things like that. So yes.
And I don't, Drew, I'm gonna, besides what we kind of talked before, have there been any other substantial repairs to the property since Ms. Stroud passed in 2019?
Like I said, as issues arose, then certain things were taken care of.
Can you
the ga-
elaborate?
The gas leak, I came to visit. That was in 2020, and I smelled the mold and mildew smell, but it smelled a little different.
Mhm.
And so I walked around and tried to see where I could find the different smells was, and it was coming from above. I in the basement at that time, and it's coming from above overhead. So I pushed the panel back because it was drop ceiling, and you could really, really smell that was the different smell. So I called the gas company because that's what I thought the smell was. And they sent someone out. It was, I think, Atlanta Light. They came out and tried to see if it was coming from the outside of the home. And because they couldn't find it around the outside, they cut the gas off to the house. And I had to actually get a company to come out, an HVAC company. The first company couldn't determine exactly where all it was coming from, so that they wanted to do a different test, but it was going to be days out. So I called another company, and they actually came on the weekend, and he did the testing and found that it was several gas leaks along the line, to the point of it was stated the house could have blown up. And so he went and got what was needed to make the repairs. Both fireplaces were disconnected because it was unsafe, or maybe that if he fixed the piping, it may still bleed through the brick. So it's a line that was fixed from part of the straight line that comes into the home. It curves off in several different locations. So some were disconnected and capped, some replaced, and there was leaks at the water heater and also the furnace. And so those pipes at the furnace were replaced and at the water heater, and then the water heater didn't work anymore. So that one I had to call a company in to have that replaced, but it's on lease. The reason why it's leased, because they'll come in and maintain the water heater throughout the lease.
And so on the appraisal, the September appraisal, it mentions that you provided a home inspection report. Oh, sorry. An owner provided the appraisal with an inspection report.
Yes.
Stating evidence of deficiencies and multiple quotes, the totaling over $126,000.
Yes, those were partial quotes, and I did provide Mr. Crosby with those, and also that I was getting additional quotes for some of the issues that were going on with the house. So he got those of what I had at the time, and also an inspection report that was done.
But do you believe do you believe that the repairs would cost more or less than $126,000?
More, because those were partial quotes.
What was not included in the partial quote? You said partial.
Yeah.
What wasn't included?
I do believe that they didn't do the complete HVAC. I'm not sure of everything that I had sent him at the time, but I know it wasn't all the quotes I was in the process of obtaining.
And Your Honor, as far as how you want to do this, is it okay if I share my screen to show something that's already in the record? I mean, as far as like being able to talk about it, if there's a better way I can share.
I don't mind you sharing your screen as long as there's no objection to the document itself that you're trying to share with me. So
yeah, I'll try to figure out
what it is you want to reference, and then let Mr. Bazzani know if he wishes to object or not.
Yes, and this might be something where right now I'm going to talk about the objection to the appraisal that was filed on November 6, 2023. As far as it's on the record, and then
Your Honor, he keeps saying that's on the record. I mean, it's been filed. It hasn't been admitted as evidence. I don't think even during the special master's hearing. So,
That was what I was
that
trying to build
something's
to.
on the record means that it was filed as an exhibit to a motion does not mean that it's been tendered or admitted into evidence. So
That was what I was trying to build to. I got cut off, but to be able to show it on the screen so we could offer it and it could be objected to at that point. I mean, it's something on the court, but as far as procedurally.
Okay. Tell me again what it is, Mr. Scriber. What is the nature of the document? I think I heard you say it's an objection that Mr. Stroud filed to the appraisal.
That's correct. And it has the attachments on it that were the relevant things that.
Tell me what you mean by that. Like, was it a document that was prepared to provide to the court? Was it a document that was prepared?
It was actually filed with the court. So it was prepared and filed on November 6th.
Hang on, Mr. Scriber.
Mm-hmm.
Was it a document that was prepared to provide to Mr. Crosby so that he could reconsider? Was it a document that was prepared to provide to Mr. Williams so he could consider it? Or was it prepared after all of that had happened for the court to consider in terms of an evaluation of the special master's decision?
Understood. So it was prepared to ask Mr. Williams to reconsider the October 6, 2023 evaluation.
Okay, and was it submitted to Mr. Williams?
Yes.
Okay.
It was filed in the court and served all the parties.
Okay. When was that approximately?
The actual filing was on November 6, 2023.
Okay. Mr. Bazzani, if it is something that was provided to the special master that he would have had the ability to consider as part of his decision, then I'm going to let Mr. Scriber talk about it, present it. Okay.
Understand, Your Honor. I do believe that they're hearsay documents because they are invoices prepared by out-of-court declarants. But I will leave it at that, Your Honor.
I understand, and your objection is noted for the record. Mr. Scriber, you may go ahead.
And yes, and the court as well. This is not things that are offered into evidence. I understand if Attorney Bazzani wants to object. I'm just gonna hopefully. Okay. And Ms. Smith, are you at a computer?
Yes.
Okay. Can you see my screen?
Yes.
So is this, can you tell me what you see?
I see the objection to the appraisal.
Okay. When I want to paste this to make sure that why did you object to why was an objection filed to the appraisal?
The objection was filed to the appraisal because of what it would cost to repair the home, and we thought that it was.
Forgive me for interrupting, Mr. Scriber.
Sure.
But I think I may not be clear on Ms. Smith's role here.
Yeah. And she is.
I understand that she is someone who has responsibility for Mr. Stroud for maintaining the property. But you just asked her a question about why she filed an appraisal, and she's not technically a party. So I need to understand a little bit better.
And I need to withdraw that. I need to restructure my question.
Okay.
Because as I was saying that, I realized it was not Daryl is the owner, but Angel Smith is his attorney, in fact, at the time that this was filed. But Ms. Smith, can you tell me your involvement with the preparation of this, as far as what you in particularly have provided for the so that the appraisal could be reconsidered?
My role in this was the discussion with Daryl Stroud of what the appraisal was, also the estimates, what was needed to repair the home, the condition of the home, and he felt that the appraised value was too high.
Did you meet with people?
Yes.
Can you elaborate on that side as well?
I met with those for the estimates. Also, a realtor, she obtained information to do a an opinion.
Mhm.
Also, an investor provided what he would actually purchase the home for, given the condition.
Okay. And as far as having gathered all that information, what was your walkaway as to what was needed to bring this property up to a marketable condition?
My opinion is that it was an astronomical amount to bring the property up to a standard of living condition, up to code.
Okay. And beyond, so you had mentioned the HVAC, you mentioned the electricity. What and the plumbing, what other things are like significant that were presented problems as far as selling this property?
You also have issues with the roof, the gutters. They're too close to the roof line, so it shoots over. They're also clogged, and also it's a two-part system that was connected into. It's a French drain clay system that has collapsed. You can see from the driveway where it's supposed to exit that it is filled. Also where they have like these connectors that go into the ground. Those are also clogged. It's in different directions of the house. Where the vermin exited out of the fascia boards. There's markings for that as well. And also there were also droppings in the attic.
Mhm.
The attic insulation
I'm gonna stop my share.
The attic insulation basically is almost non-existent. There's also mold in the attic. There's mold behind the paneling and also in the roof. Well, I can't say roof, but in the ceiling aspect of the basement flooring. So where the basement ceiling, above level flooring, there is mold and mildew there. The stairs, they're broken. Spindles, when you walk down, it's movement. Like I said, some of the walls in the house, they have cracks. The house, the stabilization of the house is off. So you have dips and leans, and the house is kind of like leaning inward. You have mold, water intrusion on various different rooms from the roof. Like I said, there's mold in various aspects of the house. Some of it was encapsulated by paneling. Now that the paneling has been some removed, some open, now the basement is exposed. Also part of the drop ceiling in the basement is broken. So now you have the exposure to that. And it also, because of the shifting of the house, well, my opinion of the shifting of the house, that some of the ductwork is now loose, broken. See what else? The plumbing, you have the old plumbing, the mixed system that was put together. And the only lasting bathroom that's there. The tiles are coming off the walls from water pressure. So that was some of that was repaired. You also have an electrical outlet that's right at the water source that's not coded. So if any water hits it, that it automatically cuts off, and that's in various different areas around the house where there are water sources. That's not correct. See, roof, attic, mold. Of the foundation is separating, shifting away. You have the exterior back of the house. You have an outdoor outlet or an indoor outlet outside. So that whole back side of the house, none of the electrical works. You have the mortar out of like the patio, that's coming out, separation. The stairs are broken on the outside. The retaining wall, it's broken. You also have to where when it rains, you have big puddles in different areas, almost moat-like. And the one in the front by the mailbox or the monkey grass, and also out in the back. You have where water comes into the garage whenever it's raining or wet, and it goes all the way across. So you have mold and mildew from that. You also have where from this incident and before you had leaks throughout the home with the plumbing aspect. So it's just a
Okay.
lot. And like I said, it's a lot of cracks. It's a lot of shifting. You have the upper cabinets are coming off the wall because the house is shifting. It's a lot.
And do you believe these were accounted for in the appraisal? The
To a
totality of it?
to a certain degree. I don't think that everything was taken into consideration. And that yes, repairs needed to be made, but the cost, the inflation, you know, with how everything is inflated, the cost that will be needed to repair those things.
Okay. And have
Mr. Scriber, I don't wanna be unreasonable, but you've reached the end of your hour. I'm gonna. let
okay,
you
I was gonna say
go ahead to wrap it
I was
up,
about to wrap it up. So you actually have good timing. Because I want to allow them to have their time. But is there anything else, Ms. Smith, that you'd want us to know about the property as far as its value, I guess?
The value is steady going down because how the house is steady deteriorating, in my opinion.
Okay. No further questions.
Mr. Bazzani, do you have questions?
Just very quickly, Your Honor. Ms. Smith, are you an appraiser?
No, I'm not.
Do you have any real estate licenses or certifications?
No, but I've been trained by the federal government for property
what?
management.
Property management, okay.
Yes.
Are you a general contractor?
No, I work with
Are
them.
you a plumber, an HVAC specialist, an electrician?
No, I work with them.
Okay,
So I'm very familiar.
okay. No further questions, Your Honor.
I have a couple of questions. I'm not sure if Ms. Smith is the right person to ask, but how long has this property, when did Ms. Stroud pass?
She passed New Year's Eve, December 31st, 2019. And I came down and started kind of like helping out with Daryl Jr. That January and February, March, I started taking over managing the house from March 2020.
Okay. Forgive me, but does Daryl Jr. have some issue that requires adult supervision?
Well, he was in college and he had an emergency surgery that November, I think it was, yeah, he had appendicitis that ruptured.
Oh, I understand. Okay. So who has been responsible for maintaining the property since December of 2019?
Well, Daryl has been managing through me since really April of 2020.
Okay. And are the real estate taxes current on the property?
Yes, Daryl's paid them.
Okay. And have there been any appeals or challenges to the property value assessed by the county for the property?
No, I haven't looked at those.
Okay.
I just went ahead and paid the taxes.
Understood. Okay. Anything to follow up on my questions, Mr. Scriber or Mr. Bazzani?
Nothing, no further.
No, Your Honor.
Okay. Thank you, Ms. Smith. You may be excused as a witness. You're of course free to continue observing.
Okay, thank you.
Mr. Scriber,
can I go off? Can I go off camera?
Oh, you're free to do that as well.
Okay.
Yes, ma'am.
Thank you.
Mr. Scriber, anything else you want to present?
Oh no, seeing as I've used my hour, I'll note nothing further, Your Honor.
Okay, Mr. Bazzani?
Your Honor, I'd call Jason Crosby as a witness.
Okay, Mr. Crosby, will you please raise your right hand? Do you swear that?
Sure.
Oh, you had it right the first time. Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You may lower your hand. Go ahead, Mr. Bazzani.
And Your Honor, just as a request to the court, I'm happy to go through Mr. Crosby's qualifications, or I could, if Mr. Scriber will stipulate that he is an expert appraiser, for consideration by the court?
We will stipulate that he is an expert witness on this. Yeah.
Okay. Thank you. I appreciate that. Go ahead, Mr.
Thank you, Your
Bernard.
Honor. Mr. Crosby, you're a certified appraiser, correct?
Yes.
When were you first licensed as a certified appraiser?
So I was licensed in 2003 as an appraiser, and then in 2006 I became certified as an appraiser.
Do you hold any other licenses or certifications?
I'm also a licensed realtor in the state of Georgia.
Thank you. How many appraisals have you performed in your career?
I have lost count of those, but on average, I'd say 200 a year.
So 200 a year since 2003?
Yes.
Okay. Let me share my screen very quickly.
I'm going to ask what's being shared.
It's the appraisal of real property dated September 8th, 2023, prepared by Mr. Crosby.
Okay.
Go ahead.
Sorry, Your Honor. Okay, Mr. Crosby, can you see?
Yes.
Okay. Can you identify for the court what this is?
This is a copy of the appraisal report I performed.
Okay. And for what property was that performed?
989 Burnt Hickory Drive, Southwest.
Your Honor, I would tender into evidence will be marked as Exhibit A, the appraisal of real property.
Mr. Scriber, any objection?
No objection.
Okay, it's admitted. Go ahead.
Thank you, Your Honor. Mr. Crosby, you prepared this appraisal. What did you do in order to prepare the appraisal?
So scope of work involved a personal inspection of the property where I came and walked around the exterior of the home, and I made measurements. Miss Smith was there, and she walked around with me and kind of pointed out all of the issues that she was aware of at the time. I measured the house to confirm the square footage. Walk into the house, I get a layout of the floor plan, take a look at the finishings to determine the quality and condition of those. Same in the basement. We separate out finished area from unfinished area. I put all this data into the report, including a building sketch. Once I look at the property, a lot of times I'll kind of research the market a little bit before I visit the property to get, refresh my memory on that neighborhood specifically. But most of my work comes after seeing the property when I try to find the best comparables. I determine the current market conditions in the neighborhood, including whether the prices are going up or down, or whether they've been stable. Look at supply and demand and all other factors that would affect marketability. And then we come up with an opinion of what the house might sell for with fair market value, which is a number that it might sell after being marketed for a reasonable amount of time for a reasonable price. But with the comps, we put those into the report. There's a grid there that itemizes all the features of the subject property being in the house that I'm appraising. And we compare that to all the comparables that I use and make adjustments for differences in there, including square footage, room count, condition, acreage, sometimes locational adjustments, all the factors that might affect the value.
Okay, and we'll get into the comps and everything in a little bit. You heard the testimony of Mr. Stroud and Ms. King and Ms. Smith. In your appraisal here, I've highlighted it or made it bigger on the screen share here. It talks about describing the condition of the property. Is that right?
Yes.
Okay. Did you describe the concerns that Ms. Smith and Mr. Stroud testified to in your appraisal?
So at the time of the appraisal, the issues that I knew to exist, I tried my best to account for all of those at the time. That testimony that Ms. Smith just provided did reveal things that were not going on at the time of my inspection. So basically, as of that date on September 8th, what she told me, she did provide me home inspection and some different estimates for repairs to the house. So I tried to take all that into consideration as best I could.
But it stands to reason that you could not account for things that had not occurred at the time of your appraisal.
Yes.
Okay. All right. Can you tell the court what different what are the methods used in an appraisal?
So in terms of arriving at a number of value, there's 3 different approaches, including the sales comparison or market approach, which is where we compare the home to other sales that have occurred in the neighborhood. And that's the most reliable indicator of value, especially with older homes. And we also do the cost approach, which every appraisal we do, we determine an opinion of what the land would be worth alone, the site value, plus the estimated cost to build the property new, minus any physical depreciation or other depreciation that might occur. And we also often will look at the income approach. We don't always use that one. A lot of the rental data that is out there is pretty limited in some of these neighborhoods where they're mostly owner-occupied homes. I did not develop that approach for this property, but that is another factor as well. We basically determine what the monthly rent might be, and we determine a gross rent multiplier for the neighborhood and calculate the value that way. Typically, if they're all done fairly accurately, they'll come pretty close to each other. But a lot of times, I'd say 90% of the work I do is for lending purposes, whether they're purchases on homes or refinances of mortgages. The banks rarely require the income approach because it's usually not as accurate in some of these neighborhoods. But the sales comparison is the main approach that's looked at.
So for this appraisal, you use the sales comparison approach and the cost approach to value, correct?
Correct.
Okay. And what was the fair market value that was established in your appraisal using those 2 different approaches?
So I came up with $265 as of that date.
$265,000. Is that an exact number, or is that a kind of in a range of values?
Yeah, so for whatever reason, as appraisers, we're bound to give a specific number. However, there's always a range where it could fall. Given the condition of this home and the estate situation, I probably erred toward the lower side of that range.
So your testimony is that $265,000 is probably on the lower end of the range of what this house may be worth.
Probably so. Like ultimately, the number I put on it is an opinion. It is an opinion based on market data and facts in that respect. No one really knows what it is worth unless you put it on the market and market it to the open public, and that usually the market will shake out what the house is worth. But typically there will always be an appraisal done, especially if there's going to be a loan involved. Even cash buyers will get appraisal sometime just to make sure they're in the right ballpark.
I guess if we can talk quickly about the comps that you looked at. I see here there were 3 comparables that were looked at for this particular appraisal. Is that right?
Correct.
And then what were there's a sales price here sorry, I tried to highlight it, but we've got 250, 235, and 319. Is that right?
Correct.
Okay. Can you tell us a little bit about each of the comps and
Sure.
how those comps help you determine the value of the subject property?
Yeah. So as a quick overview, we in picking comps, we We prefer to stay within a mile of the property, and we stay within a year for a sell date, the year preceding the effective date of the appraisal. In some cases, we'll go beyond a mile. In this case, that first comp is 1.62 miles away. And the reason we went farther out is to make sure that we're best taking into the condition of the property. So to my best analysis from the listing information I had for that first comp, it looked to be relatively similar condition. Sometimes sometimes there's limited information out there, but this one had a lot of photos. What I noticed for this, some of the agents' comments were quote unquote perfect for investors or owner occupants to do a full remodel. It's a fixer upper. I did notice in the pictures that there was, older carpet and vinyl flooring that was worn that should be replaced. There was plants growing out of the gutters. I noticed on the back of that house in the pictures where there were some previous cracks in the bricks that had been filled. No updates to the kitchen and bathrooms. On this home, the subject property, I think it came up earlier in the examination or the testimony that was given here today, that I noted that the bathrooms had been updated, which they had, so that, I don't know exactly when, but they did do it, updates to the bathroom. I would say probably 10 years or more before the time I got there. But apparently, according to Ms. Smith, and it's obvious from the, walking through the house there, that there were some leaks and stuff that were going on. Perhaps some of that renovation wasn't done well, but at the time, those bathrooms had been updated, but there were some issues. So the kitchen had not had a lot of updates to it on the subject property, but this comparable one, there were no updates to the bathrooms or kitchen or anything like that. So to me, it felt like it was pretty similar in condition. Also too, I think in this market, someone buying this house is probably going to be an investor. And in comparison to the comparables that I have here, especially comps 1 and comp 2, I felt like from the information I had from them, they would be the same candidate. It'd be someone that an investor would come in, most likely, the subject property here and these first 2 comparables. I think an investor would buy those and probably gut them. And who knows what they'd find at that point, probably some similar stuff that's going on in the subject property. And they would buy these and completely renovate them, and sell them in the neighborhood of upper 500s or more.
So is it fair to say that your testimony is that your fair market value, it takes into account the fact that this is probably a gut and remodel?
Absolutely.
So it doesn't really matter what the inside looks like right now. You're looking at a fair market value based on the idea that it's going to be gutted and remodeled.
Sure. I mean, to a degree, it doesn't matter what's going on inside. I noticed, apparently the toilets and the flooring had been taken out. Obviously, you'd need some toilets in there. Those things would be considered deferred maintenance and some deductions made for that. But I do think that someone buying this house and those first 2 comps are going to come in and redo the whole place. And
sorry, go ahead.
So for example, that third comp, I felt like it was in fairly good condition compared to the subject property. There were a few updates. The kitchen had been updated to a degree. The comments in the listing said that there was a newer room with architectural roofing shingles, a newer HVAC and things like that. So I made a 20% condition adjustment for that. A lot of times, which I think is pretty generous, in doing appraisals, especially for lenders that are backed by Fannie Mae, anytime you make an adjustment in your appraisal for more than 10%, it's considered a red flag. Unless you have a good reason, you usually have to put an explanation into why you made an adjustment over that. So this would be an example of that. So I made a generous adjustment for it. A lot of times the cost to cure a problem may far exceed to exceed the value that it gives to the property, especially their components that are integral to the soundness, safety of the home. The investment on return, the return on the investment is not always the same for that. So some of these repairs would be pretty costly, but the cost to do it would not necessarily equate to the value of the house. And I did review a lot of estimates that Ms. Smith provided to me. There were several different ones to the point where it was kind of hard to keep them all separated. But I do remember some of those, like the plumbing, the electrical. So those were quotes that they would basically replace every wire in the house, every outlet, the panel, the supply to the home, switches, ceiling fans, light fixtures, exterior light fixtures, like pretty much anything that is powered by electric. A list like that was included in the quote. I don't think that that would be necessary at all to bring the house to a more acceptable standard of living. Like in the HVAC, for example, I noticed some stains from the exhaust, from the registers in the house. That's not too uncommon in older houses, especially if there's not been a lot of painting and stuff that's happened over the years. Obviously I'm not a home inspector, so I can't really attest to how the systems were functioning. I do know it was like the first week of September, which is still really hot in Atlanta. And I don't recall being uncomfortable in the house. I think it was working at least to the point where it was effective. The same with the plumbing quotes that I looked at. They were quotes that you'd replace every piece of plumbing in there, including the original cast iron, all the supply lines, even some of the fixtures. So I think some of those quotes were far above the scope of work that would be needed to get the property in more acceptable living conditions.
But just to be fair, you did consider all of those invoices in your determination of the fair market value.
I spent lots of time going through them. I don't know if anyone recalls, the report took me quite a while to finish. And the reason for that was that I just wanted to make sure that I was getting it as right as I could.
Do you take into account market conditions when putting together an appraisal?
Yes, for sure. So for example, in this report, I noted that we look at property values. They definitely increased over that year before the effective date. And the marketing time is kind of low. It looks like I noted that there was a bit of an oversupply at the time. But we definitely take into, whether the prices are going up and down. In fact, on all of my comparables there, you'll see I made some time adjustments for them for having sold, a few months before the effective date. A lot of times we'll try to include some sales that occurred within the previous 3 months or even some active listings. But in this case, I didn't really find any at the time that reflected the condition of the house that well. So we went with 3 comps that were over 3 months old.
And again, not to keep this short, what is your opinion as to what the fair market value of the subject property is?
So as of that date, I arrived at 265, and I belabored on that pretty hard at the time. Again, that is an opinion based on market data and facts. It's not the end all be all, but that is a great place to start.
Your Honor, I don't have any further questions for Mr. Crosby.
Okay. Mr. Scriber, do you have any questions for Mr. Crosby?
Oh, yes, Your Honor. Mr. Crosby, thank you for being here today. I know it's not the most fun thing to do on a Wednesday afternoon. I had some questions about the overall appraisal. So I'm gonna. Do you have a copy with you? I can refer to it, or
yes.
Okay. On the what page is this? On the 3rd page, I believe it talks. It has the comparator properties that you use? The
Mhm. Yes, the sales comparison.
Yeah, so on your report you had mentioned that 1 and 2 had the most similar condition. Is that
Yeah,
accurate? And the first one was 250 and the second one was 235.
correct.
Is that how did it go from how did you go from that comparison level at 250 and 235 to having this property be valued more than those?
Okay, so as I was talking before, we'll make adjustments for any of the components of the homes that are different from the subject property. So if you're looking at that page, which is page 3, and you'll
Yeah.
see it's a grid. The subject property is in the left column there, and the comps are lined up next to it on the right. So you'll see, like, for example, the site acreage, we make an adjustment for those. So the subject property was just slightly bigger than those lots for the comps, so those adjusted up a little bit. As I mentioned, the sales occurred over 3 months ago, so I made some adjustments for the time, which were upward adjustments.
Yeah.
On that third comp, you'll see, like, maybe the first or second line down on the grid where I made some negative adjustments for seller contributions. A lot of times during the sales process, some issues might come up in the home through an inspection, and buyer and seller negotiate some money back toward the buyer to kind of account for those or go towards closing costs. And so we'll make adjustments for those if they're above what is typical for the market. The square footage or gross living area, which is kind of midway down, it's right below the room count. So the first comp was slightly smaller, so we adjust up for that. Same for comp 3. Comp 2 is a little bigger, so we adjust down for that. We adjust for overall basement size as well as finished area. We also employ a technique called bracketing when we select our comparables. A lot of times it's hard to find a house, especially in these older homes, where one house is truly exactly like the subject property.
Yeah.
So in order to, account both something on the high side of a certain feature and a low side, we'll provide at least one comp. For example, for gross living area, 2 of the comps are smaller in size, but I also provided that second comp, which has larger square footage. So we're bracketing that square footage. Same with the basements. You'll see these all have like fairly similar basement utility. We also make adjustments for room count. Typically in a house in this market, a house with 3 bedrooms or 2 bathrooms, we'll just make adjustments for bathroom differences.
Yeah.
Which I did here. Adjustments for a carport as compared to a garage. And so after all that adjustments, you'll have a net adjustment. And typically, if you have everything bracketed right, you'll have at least one comp that adjusts up from its sales price and one that adjusts down, which we have here. So comps 1 and 2 adjust up after all the net adjustments, and comp 3 adjusts down.
So
the reason they adjusted up was they had more features that were inferior to the subject property.
Okay.
Overall. Yeah.
And one of the things I see there it's hard to describe words on the screen, but it's clear at the bottom. It says prior sale date. In the comp 1 has a prior sale date of September 2nd, 2021. And then a data sale time further up of June 2023. So maybe about 20 months or so between the sales. And then comp 2 has a prior sale date of September 2022. And then I guess the recent sale date, was it later that month, it looks like, between the two. Does that, what does that indicate? I was asking as far as
In-
what
In
those
these
mean as far as the
cases,
difference.
not much what it indicates. So what these, so as appraisal requirements mandate that we report the sales history for the subject for the 3 years prior to the appraisal date.
Yeah.
And we report the sales history for the comparables 1 year prior to their sell date.
Like,
I go a little above and beyond and we'll go back a little farther to the most recent sell if it's over a year for the comps. And in these cases, they were all, none of them were market transactions. They were either quit claim or an affidavit, which I don't have the sell history in front of me, but typically that'll indicate that these are probably estate properties that have been transferred, to an administrator of an estate or from an administrator. These are probably selling out, of an estate settlement. So in that case, they're similar to, and like if this home were to go on the market, these kind of take that situation into account as well.
But I guess what I was getting, were there any improvements made in that period of time between as far as between the two sale dates?
I have no hard evidence, but I have a lot of reason to assume that there was not, at least for the first two comps. Yeah.
Is there something different for the third comp?
So that comp was in better shape. I don't know if anything was done to it between that transfer date, the prior transfer date, but I know that comp had some updates to it. I don't know how far ahead of its sell date, but some updates a lot more recent than the subject and the first two comps.
Okay.
I will point out too that second comp, just to talk more about the condition of it. Comments in the listing stated that said beware mold damage. Sold as is, no disclosures. Wear a mask. Needs a magic touch to be brought back to life. So much potential and value to be added.
Was that included is that in the report?
The comments, a lot of times I will mention that. Sometimes I'll just kind of summarize my findings. And I think here I probably just said that these appear to be in the most similar condition to the subject.
Okay.
Without giving too much detail about it.
And then
I always offer the client or the reader of the report to give them copies of the listings so that they can look at the pictures and the comments in there as well. A lot of times, like as an appraiser and a realtor, we have access to private remarks in the listings, which don't always make it to the general public if they're viewing a listing like on Zillow or Realtor.com, for instance. But that's where you'll find the more.
Oh, sorry.
Yeah.
Are you a realtor?
I am a realtor.
Okay. And do you also, and there's kind of the gradations of, do you also inspect as well as far as, like what you can price in as far as what you're able to, what you're able to evaluate at a visit?
I'm definitely not a home inspector, but I've seen lots of home inspection reports. I always like to give a disclaimer in my report. There's probably one in here that says that I'm not a home inspector. But a lot of times, like especially if I'm doing an appraisal for FHA, if we find some deficiencies with the property, we're required to give an estimate of what it might cost to cure the problem. So oftentimes I'll look at inspection reports. I have in my sphere, I have a few different contractors that I'll, get their opinion on sometimes as best I can.
Was that done for this appraisal?
For this one, I do not recall specifically if I talked to any contractors about it, but I did have the home inspection and all of those estimates, which appear to be from reputable companies.
Okay. The home inspection, let me. Help me out. So I'm not seeing a report. Is that a home inspection, something that you had someone else to do? That's part of it.
Yeah. Daryl and Mrs. Smith. I'm not sure which one ordered it. I assume Ms. Smith facilitated the home inspection, but Yes, she provided me a copy of it.
Oh, I get what you're saying. So it was inspection that was provided to you. It
Mhm.
wasn't something that you had
Yeah,
ordered.
and it may have,
Okay.
that one actually may have been from a little farther out too. Let me,
Okay. Okay.
but yeah, she did give me a copy of a report from a home inspector that she had hired to look at the home.
Okay.
Yeah.
And I know you had in your report, you also had mentioned that I'm just trying to find the page. Oh, that I'm looking, I think on page 2 that per the S&P Schiller Home Price Index, median sale prices increased 3.35% since September 2022
Mhm.
and 5.86% since January 2023. Is that accurate as far as you know?
Yeah, so actually, if you'll go and look at page 7 of the report.
Oh yeah, I'm gonna jump to the addendum,
yeah,
right?
there's a copy of that index.
So I guess that's to say, like, how do you think how much more significantly has the market, as far as you know, changed in its growth since then?
Okay, that's a good question too. So yeah, the most recent issue of that index came out on April 1st or the last day of March, and it's been pretty stable overall since then. Let me find a copy of that to reference for you.
Okay.
A minute. Yeah, so that was issued on March 26th. And since September of 2023, which is when I did the appraisal, this index is showing a drop in prices of 1/3%. So nominal.
So
that.
I guess, yeah, I guess that's what I'm kind of getting at, because I know you in your prior testimony you had mentioned that just at the low end of the range that you had, 265. But is there any evidence that range? I mean, I'm trying to gather why that would be, because all the comparables are less than 265, and the growth hasn't seemingly changed that much.
Yeah, I'm not sure if I understand the question.
I guess so. I'm gonna break that because I apologize. So what causes there to believe that this would be the low end of a range of the 265 that you arrived at? As you're saying, the market hasn't grown.
Yeah.
The other comparables actually sold for less money, except for that. So by that, like, what's your basis? I want to make sure I understand.
Yeah, so like when I'm determining the market, in this case, I said, the submarket was considered to be, what do I have here? All homes located within 1 mile of the subject. So, and those are also single family detached homes. So it's excluding any townhomes or condos, which is really not much in that mile radius there. It's mostly single family homes that are fairly homogeneous to the subject. The price range I came up with for that submarket that I defined was 154,000 to 725,000.
Sorry, can you run that one more time?
Yeah, it's 154 to 725. And the predominant number, or the median number at that time, was 409. So we're still like way below that median of 409. And toward the low end of that price range of 154 to 725. Now that 154 is going to be like much smaller homes without crawl spaces. Could be smaller lots. Every neighborhood is different in terms of its marketability or desirability for the average consumer. That 725 is going to be maybe a newer home that's a lot bigger, better shape. A lot of times these homes are, the ones selling at the lower end of the market are gutted, renovated, added on to, and become sold again at that higher end of the range.
Okay. But the two comparable, as far as you know, all three comparables, they were just sold as, I guess, as is. They weren't torn down. They weren't purchased for the land or purchased for the whole structure.
Those first two, it's my opinion that whoever bought those fixed them up. And
after the sale or before?
After the sale. Yeah.
Okay.
Yeah.
And I know you have the limited amount of data. I just want to make sure I understand what was factored in.
Yeah, and I just put these 3 comps in here because they were the best ones that I could find that bracketed all the features of the house, including the condition. There were several that I looked at and analyzed and belabored over whether I include them or not. I actually put more comparables in the report, made all the adjustments, and after the adjustments, they just kind of didn't make sense because they were that much more different than the subject property.
And I apologize. I don't want to rush you. I just want to make sure I get it in because I know we're nearing the 2 hours. But on the cost approach on the 4th page, how does both the cost and is the cost approach come to a different number than a sales comparison approach? I'm a little bit confused why they both arrive at the same number.
If they're done fairly accurately, they should come pretty close to each other. So you'll see, I start out with the site value, and the opinion of site value was 55,000, and up above that in that section, I gave all the comparables that I looked to determine that site value. These are sales of vacant lots in the area. Sales and listings.
Yeah. Are they assuming that each acre is, I know each plot's a different size, but assuming the same general.
So I kind of come up with like a average cost per acre and kind of apply that to the subject lot size. And then we use cost guides such as Marshall and Swift Cost Handbook. There's several out there, and determine like cost per square foot those are replacement costs. So that's what it would cost to build a new house.
What would the 245?
Yeah. So if you'll see like in that box on the right side of that section, dwelling is 2130 square feet. That's the main floor. That was $115 a square foot to build that. The basement there's that second line is the basement, 1649 square feet. A little bit less cost involved in that because it's part of the structure, is foundation, discounting for the finishings, $62 per square foot for that. Garage costs about $25 per square foot. Miscellaneous items, $31,000. That includes like appliances, porches, patios, things like that. And then, so the total estimate of cost new was roughly $393,000. However, the home was built a while back, so there's been some physical depreciation, obviously, too, with the deferred maintenance that's gone on. And I came up. So what I do to account for that is I give the house an effective age.
What was the effective age?
Effective age I said was 27 years. That's basically okay. This house is in the shape that a house would be if it was built 27 years ago, and absolutely nothing had been done to it. Like the elements, people living in it, and then we come up with a physical depreciation. What we do is we determine an economic lifespan. Like what would this house typically? How long would it live before it falls over without doing anything to it? And I said it's about 55 years. And so then we divide the 55 years by the effective age, and I came up with 49% physical depreciation, which is, almost half. So I feel like I was pretty generous in taking account the shape of the house with that. And so after calculating all that, it comes up to a number. So it does come exactly. A lot of times we're doing these for banks. They want them to be exactly the same, and so you can kind of manipulate the data to a degree to make it match exactly. But if it's done right, which I have all this information that I looked at cost data for, that miscellaneous items will kind of adjust that a little bit to.
What are miscellaneous items?
So those would be like porches, decks, patios, fencing, appliances, built-ins. things like that.
Were those present at the house?
So when I was there, if I recall correctly, we can look at the photos, which are on, they begin on page 12. So
Yeah.
those are outside photos. So there was, yep, it's a dishwasher.
Is that included in the miscellaneous?
Yeah.
Okay. So
And
those
are
appliances.
those are like the cost new. Yeah.
Okay, I'm just trying to crunch the number. I just want to make sure.
Yeah.
Sorry. The reason I didn't see any external stuff on it.
Yeah, so like external stuff, if you go back to that cross approach, as is value of site improvements. So site improvements are like grading, drainage, walkways, driveways, things like that to help improve the site for building. And all I applied to that was $10,000, which, you know, if you went to build a house, you would be a new house like this would be over $50,000-$60,000 at least to prepare the site just to build on it.
Okay. And I'll stop my questions, but thank you so much. I appreciate your time.
Yeah.
Thank you.
Pleasure.
Mr. Bazzani, do you have any additional questions well, actually, before I do that, I have a couple of questions.
Okay.
Hi, Mr. Crosby. So,
Yeah.
In your cost approach analysis, you started with a site value. How do you arrive at that site value, and do you make reference in any way to the tax value that the county has appraised for the land?
I do
Not
look
the
at
assessed value, but the actual total value before the
correct.
reduction.
Yeah, so I will look at that as a reference point, but I've yet to. I think a lot of times with the county, they don't really do a full-blown valuation. I'm not exactly sure what algorithms they use to come up with values. I do a lot of appraisals too for tax appeal purposes.
Okay.
But it seems like a lot of times their land value might be associated with a percentage of what the overall value is.
Okay.
So in these my appraisals, that on that page, which is page 4, that first section contains 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 different comparables that were vacant land sales or listings.
Okay.
Yeah, so that's where I came up with that number.
Okay. Now, I know you testify that you are both a licensed appraiser and also a licensed realtor.
Yes.
So I assume you're probably, when you're not wearing your appraiser hat, right, are familiar with the idea of a competitive market analysis that are sometimes done by real estate agents or realtors
Sure.
for properties. I have seen sometimes where the appraised value doesn't necessarily line up with the competitive market value. Do you feel like yours takes that into account? I know obviously your appraisal is intended to take into account market forces, but if you could speak to that a little bit in terms of a competitive market analysis compared to what you've done.
Sure. So competitive market analysis is an opinion provided by a realtor. So they technically they'll look at the same types of comps. They're kind of searching the same parameters. A lot of times they'll include expired listings and withdrawn listings. They look a lot at active listings.
Mm-hmm.
We focus on closed sales. I know that. So I'm in the Keller Williams office with Metro Atlanta. We have over 250 agents in there, and it's like the biggest thing that agents struggle with. In fact, they hire me all the time to look at their CMAs, and at some point they'll even have me do an appraisal because they cannot figure out what to list it at, or they can't agree with the owner sometimes on what it might be. So it's not always as accurate. It's certainly not an appraisal.
Okay.
So what they do, and sometimes I've seen them where they will make adjustments to the comps for the differences, but most of the time they don't. I did look at the one that was provided in the motion to reject the appraisal. And if you'd like me to speak to that, I could.
I
Yeah,
would.
and Your Honor, I didn't ask him about that since it had not been introduced into evidence.
And I don't want to get into the details of it, but
Okay.
that is why I asked about it, right? Because I am aware that that was a matter that Mr. Scriber had raised in his pleading. And so I thought I would just inquire with Mr. Crosby about it a little bit.
Yeah, so I did look at that, and the realtor, she provided a sales price range of 150 to 175. She did put a little note in there about what is a CMA, how is it created, how accurate is it. I will note in her paragraph of how accurate it is, she goes, CMAs can vary widely depending on the knowledge and skill of the person inputting the search parameters to the software, as well as the number and type of data fields that are chosen. That means some features may not be included. She provided 4 different comps, basically. They were, one sold for $288. One was a pending sale with a list price of $321. One was a sell for, I think it was $315 or so. That comparable, I looked back at that one, and there was a pretty erratic sales history, including a foreclosure where the investor looked like he got a construction loan to fix it up, and it, wasn't, he lost the property through that. It looks like that one sold renovated, but at a fairly low number, but I think that was affected by the foreclosure situation. And then she provided, so basically all the comps she provided all sold or were listed for well above what the price range that she gave, but she didn't really give any reason as to why. She did give provided an assessment card for the subject property that had what she said was after repair values. And those range from 304 to 393. She said, and those were all done through automated valuation models, which are like Redfin, Zillow's estimate. And I can't tell you how many times I've had to talk to homeowners about, well, I looked at Zillow and it said this, like, especially in a neighborhood like this where the homes are older and they've been modified and changed over the time. There's not many houses that are exactly like one another. Those models are way off. And I don't know how she could have said it was after repair value, because you can't even really enter those parameters when you're searching for stuff like that. I just think that, in my opinion, this CMA that was provided is not really worth the paper that it's on.
Okay. Let me ask you, is it so I think I understand that you believe you did the best that you could to try and take into account the fact that there might be deferred maintenance or other structural or integral types of repairs or changes that needed to be made to the house to make it either more sellable or more comfortable for someone residing in the home. Is that accurate?
Yes.
Okay. So is it also correct, though, that it's not a matter of, for valuation purposes, it's not a matter of the house is worth $250,000 as it is, but you have to spend $100,000 to make it more habitable or better. So the house is worth 150, because I think I see that effort at evaluation. I think I understood your presentation to be that that's not how it would typically be taken into account in terms of a dollar for dollar reduction on the amount.
Yeah, correct. For example, all the quotes that I was given, it's basically like replacing every component of the house.
Right.
Which, if you did that, it would be worth a lot more, but probably not if they're saying.
And that was my next question is it also correct that if you did go and spend $150,000 on this house, it'd probably be worth a lot more than even you have estimated it to be worth at the 265?
Yes.
Okay. Okay. Those were all the questions I had. Mr. Bizzani, did you have any additional questions based on those questions?
No, Your Honor.
Okay. Mr. Scriber, did you have any questions based on those questions?
Nothing, Your Honor. No further.
Thank you, sir. Mr. Crosby, you may be excused as a witness. You're, of course, free to jump off or stay on, whichever you
All right.
prefer.
Thank you.
Mr. Bizzani, did you have anything else you wish to offer?
I do not have any other witnesses, Your Honor. However, I would like to make an oral motion for attorney's fees and costs pursuant to 915-14 regarding this hearing. This hearing, there was no additional evidence offered that was not offered during the special master's hearing. There's no contesting of the appraisal with a counter appraisal. This was based on opinions of people who are not certified appraisers. They're not realtors. They're just saying, we think that this should be lower. They didn't offer a lower, what the lower amount should be. And all this has done is delayed a process that is supposed to be fairly quick and efficient. It has cost my clients time and money to attend this hearing, hire Mr. Crosby as an expert witness for no real purpose. And there's no justifiable dispute here that Mr. Scriber has raised in his objection to the special master's report and recommendation.
Okay. I will take note of your motion.
And Your Honor, would I have the chance to respond to that motion in writing? But it's a good faith objection. There is a counter appraisal that we entered in the record. We did not submit it as evidence, but it has been submitted. It has been obtained. That offered it at 230.
Okay, so I'm going to make a note of Mr. Bizzani's oral motion. What I was going to suggest is that we conclude this matter, and then Mr. Bizzani can file, whatever brief filing he wishes to file to perfect that issue. I mean, you've made the motion, but just so that there is a record of it, particularly regarding if you're seeking the recovery of fees, what those fees are.
Absolutely.
And then, of course, Mr. Scriber, you would be given an opportunity to respond both substantively to the basis for the motion, as well as any challenge you had to the amount of the fees and costs sought in the motion. So that's how we'll handle that. As I understand the current motion before the court, hang on, I have notes here and I can't find what I'm trying to reference. So as I understand it, the special master's valuation at the $265,000 was the special master advised the parties that that was his determination of valuation based on the evidence that was presented to him. And an objection was filed to the appraisal. And that the special master's recommendation is that the court rejects the objection and accept and declare the fair market value of the property at the $265,000. I am persuaded that the special master conducted the review that the court requested that he conduct, and he based his review and determination of the value of the property on the best information and evidence that he had at the time. That the appraisal that was performed by Mr. Crosby was a good faith valuation of the property, and that while I am sympathetic to Daryl Stroud's position in terms of his argument that there are a lot of repairs that need to be made, that last set of questions that I asked Mr. Crosby, I think underscore the point that while those repairs may ultimately need to be made, they are not, it's not a dollar for dollar reduction of the value of a home when a certain dollar amount of repairs need to be made. And so because of that, I don't know that there's any reason, I've not heard any legal or factual reason for the court to reject the special master's determination. a recommendation of the order of the fair market value of the property. And so I believe, Mr. Williams, that you had previously provided the court or that you had offered to, but maybe not yet provided the court with an order determining the fair market value of the property to be that 265. Is that correct?
That's correct. I've offered, but I've not provided, but I can.
Okay. If you would please provide the court with that proposed order, I would appreciate it. I will note for the record that it will include an overruling of the objection that was filed by Daryl Stroud to the valuation proposed by the special master. And then my question is, typically in partition actions, where we go from there is there will be a process by which the parties can either decide to buy one another's interests out or place it on the market for open market sale. Is that what you expect will happen next, Mr. Williams?
Yes, Your Honor.
Okay.
And Your Honor, this is this is a partition under the Heirs Property Act. So
Yes,
there's a
sir.
statutory rules that need to be followed, which the next step would be Mr. Stroud would have the ability to elect whether to purchase the petitioner's portions of the property at that fair market value.
Right. And I sort of glommed over that, but I understand. I mean, the idea is what happens next is Mr. Stroud has an opportunity, Daryl Stroud has an opportunity to decide if he wants to, and then to actually purchase out the other interests. And if that cannot be accomplished, or if Mr. Stroud elects not to do so, then the next step would be some sort of sale. I assume because it's an heirs partition that it would be a fair market sale, correct? I've dealt with a couple of statutory partitions where it was like, it was bananas. So let's just.
Yeah, my understanding is that the special master would sell the property if Daryl
Right,
rejected.
but I think I've seen paperwork from Mr. Williams that your intention would be to retain the services of a properly licensed.
Of a realtor, correct.
Yes.
Of a realtor. And Your Honor, early in this case, we did enter after a status conference with both counsel, a scheduling order that kind of laid out that structure. Now,
Yes, sir.
all of those deadlines have kind of been
course.
blown through, but I can revisit that with both counsel and make sure to get this back on track.
Okay. I just wanted to follow up on that issue, just so I had some idea of what that timing would look like. Okay, I think that concludes the matter for today. Mr. Williams is going to provide me that proposed order. Mr. Bazzani, you can file whatever you wish to file regarding this hearing and your oral motion that you made a moment ago. And then, of course, Mr. Scriber, you would be given an opportunity to perfect that. I will say that although you have made an oral motion during this hearing, because there's no record of it, you know, if you wish to pursue it, you're going to need to file something so that we have a clear timeline and a clear opportunity for Mr. Scriber to respond to the extent that he chooses to do so. Anything else that y'all need from the court, Mr. Bazzani?
No, Your Honor. And just to be clear, I will be filing the motion directly to the court, not with the special master.
Okay, Mr. Scriber?
Nothing, Your Honor, and we'll be filing a response within 30 days.
Okay, Mr. Williams?
No, Your Honor.
Okay, well, thank you all very much for your time and for your presentations, and I will see you again if I need to see you again. Otherwise, I'll get the orders on file for you.